Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
As the agent for Ayden, Ansley, John Milton, you are indicating to me that you're quite familiar with Ayden, Ansley, John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Ayden, Ansley, John Milton, as written in all capital letters.
All right, and you understand for my purposes, that language doesn't make any sense.
No, I do not.
I understand. Okay, well, I'm telling you that. And so until you disabuse me of the motion, or the notion, I am inclined to believe that you are both the agent and the person. And it's in
I'm
all
not
caps.
a person, I am one of the people. Thank you.
Thank you. I'm one of the people. Welcome to the Court of Public Opinion. I am the Recovery Addict, one of the people here for you here today. Happy Thursday morning. It's wonderful to be with you this morning. Thank you all for joining me. Let's see. I'm having some trouble with my computer. There, fixed it. We're good. Hey, I know what I'm missing. I'm missing an iPad. It's just a small thing, but we are missing it. So let's see. We'll get it working without this. Okay. I'm gonna turn that on and this off and this on. We're good there. Okay, audio's good. Switcher. I think I can. See. I think I can bring on my words. This live stream is the best. Thank you, sample user. Oh wait, sorry. Golden girl. First in chat this morning. Many times you have won and offended previously. You've been quite a while without an offense. Congratulations, though, Golden Girl. You've once again appeared first in chat, which means you are the rightful owner of all things IP-related worldwide for the day, or at least until we go live again. So let's see. I saw somebody talking about Sarah Boone. Is there a new document out there? I have not seen one, if there is. Good to have you here. We're sort of on time crunch. We've just got a few minutes before court starts. As a matter of fact, I think we've got. Let me just check. Yep, we've got the court camera running for us right now. Let's see where's the good stuff. We need a spicy meter for this case. We really do. Let's see. I'm trying to get everything working here. Let's turn on. Let's tie DSK2. And then do a little dissolve. Boom, there's our objections. It's weird to run this without an iPad because my iPad is the interface I normally work on this with. But that's neither here nor there. We have to handle birthdays first of all, in case there are any. Let's see. First of all, Ellie Veldman, Yellow Courthouse. Woo woo! 6 months. Good to have you here, Ellie. Thanks for your continued support of the channel. That is just amazing. That's huge. That's awesome. Do we have any birthdays? Are we birthday free today? I have not seen anything in chat with a birthday. My mods will let me know if I missed something, though, I'm sure. Let's see, do you see the clip Tayo Toys put up of you? It's funny. It generally is funny, but I have not seen the latest. I imagine it has something to do with me narrating the sidebar with no audio. I'm just guessing. One of the RAs have the iPad, could possibly have it. We'll see if I can round them up. Ellie, you're here for 6 months, and you gifted 5 memberships this morning. Way to kick off the morning. Thank you so much, Ellie. That's amazing. That's awesome. Eileen Thurling, Denise Cullern, Melissa T, Stacy S with the butterflies, and Janice all gifted memberships. Thanks to your generosity. Let's see. We've got some video happening of clerks, court clerks. No audio yet. Give us the audio, please. Let's see what we can pull up here. Oh, that's not it. Let me go back here. Helps if I use the right button for everything. On a different computer, different input. Let's go over here. Do have some good news. Had some great news last night out of Adams County, Colorado. The court just released an update about the a case that we're looking forward
Happy
forward
Thirsty
to.
Thursday. Thank you for streaming.
I had requested privileges on for streaming, and I am one of the named parties that's able to live stream a case. That one actually goes into jury selection tomorrow, and then we'll begin. I think it actually continues jury selection on Monday, maybe even the day after. But the one restriction on that case is the judge says, he told me, Law and Crime, Court TV, and a couple others that requested it, that we are authorized, we're the only ones authorized to rebroadcast the live stream. But we cannot live stream the live stream. It needs to be delayed. So I'm not sure if we're going to do a day delay on that or what. But I also might have to buy just a few $100s more worth of equipment so that I can have that recorded separately, because anyway, it just gets a little tricky. So we'll get that sorted out either way. Let's see. Let's get this full screen. There's that. Okay. All right. I think we're all good. We're all good on everything. I'm not sure which feed is soonest. Let's go with this one. All right. Did I see no birthdays? Is that what I saw? I haven't seen any birthdays. This would be the first day in a long time we have not had any birthdays, but that's all right. I'm sure that we'll make up for it tomorrow. Maisla says, love this home. Thank you. 8 months, Maisla. Appreciate your support. It's been wonderful having you here. Would not be the same without you. Does my camera look a little high to you? I mean, not like 420 type stuff, but it's just like elevation looking down on me. Do you see like my bald spot? Is that a little self-conscious here? All right. What else do we need to handle today before we begin? No birthdays as of yet. That's fine. That's all right. We will sing another day. Let's see. I literally just awoke from a dream of meeting RA. Sounds like a nightmare. It involved bees, Ocean Beach, and another TC, true crime YouTuber. Listen to learn. I hope it wasn't too much of a nightmare. Oh, there we go. Krista Roney. Krista, we're going to go ahead and sing to you. You might be the only one. It's rare. It's rare to get a solo, just for you on the birthday song. Let me clear my throat here. I need water as well, which I have none of. Hold tight 1 second. All right, the water delivery has been ordered, and I think the iPad might show up as well. But let's, Krista, I'm just going to go ahead. I'm just going to give it a go. 6 volts got the harmony. Are you going high or low? 6 volt, high. Okay, sounds great. 2 octaves, sounds great. We'll look forward to it. I'm not just kidding. Here we go. La 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 la. Happy birthday to you. Happy birthday to you. Happy birthday, dear Krista. Happy birthday to you. Happy birthday to Krista. Did we have another one in there? Did I miss one? Mary Viviano's granddaughter. Happy birthday, Mary Viviano, to your granddaughter. I think that's, I've got water and I got the iPad. Thank you. Krista, I hope you have a fantastic birthday. I really do. It only comes around once a year, so it should be good, right? All right, we are fully stocked on the water. The iPad is here. I just need to plug it in. We're good to go. Krista, there are many places you could celebrate your birthday. Many, many places. And it's not lost on me that you are here with us today. And Krista says, I love singing to someone with the same name. Yes, little Ari. Do I need a mug? I would need a mug. You choose the color. I think we're going to get a water pour in. Which we haven't done one of those all week. Let's see. Any other... Has Sarah Boone, new lawyer, filed a motion to withdraw from her case? I haven't heard if they have. I can do a quick check. Thank you. The mug today is pink. If you got one, drink along. Do a quick record search for Sarah Boone. I think Greeners would have told me had there been something happening here. Let's see. State of Florida versus Sarah Boone. It's taken forever to respond. I'm not seeing any new documents on that. So if they have been filed, they have not been. If they have been entered, they haven't been filed yet. Okay, now we're cooking with fire. We're getting there. I think I'm all set up. Quick little pour, and we'll be ready to go. So here's your warning.
Are we going to address
That's good water.
Jurisdiction?
All right. Where are we? You think there would be more letters, says Courtney? I think there will be another letter before we begin. I think Sarah Boone's gonna write. She needs to write. She needs an outlet, and she doesn't have one.
Bring the jury.
I still don't have my phone plugged in properly, but we've got everything else.
I'm not a cat.
Let's see. Melissa says, my gifted membership ends in 2 days and I can't find where to keep it going. I think, Melissa, if you're looking at chat, at the bottom of chat, there's a little,
I'm not a camel.
Looks like a little dollar bill, a little box with a little dollar sign in it. If you click on that, I think it has both the super chat and membership options in there. But don't quote me on that. My kids are the cutest. I'm sorry that everyone else lost that contest. My kids did win. So, do we have a witness lineup today? Rudy Patootie, we have the witness lineup that we were given yesterday, but that does not necessarily mean that it's the witness lineup for today. We've heard that we're going to have a DFC coordinator. We're going to have the 3 Kalowskis talking about damages. So we're going to have all 3 in court, Jack, Kyle, and Maya. We've heard, originally they said they were going to have Jessica Blackburn or Blackjack or something. I don't know what her name was. Deborah Salisbury, Brian Gillis, Eli Newberger, Dr. Sally Smith. They've thrown all these names out, but latest was DFC coordinator and Kalowski's, and maybe one other. So we're not sure exactly which one they're gonna go with today, and they might change it at the last minute as they have previously. Ooh, the docket just posted Corey Richens' 52-page motion to dismiss all charges due to prosecutorial misconduct. Hey, look who's here. Look who's here. Hold tight.
Please be seated, everybody.
We're seated. In fact, now I put the judge right in his seat. There we go. Anyway, Denise, thank you very much. 5 months for your support. That is fantastic. I appreciate that.
Number 2018 CA 5321, Kowalski versus Johns Hopkins.
Okay, I'm going to...
All Children's Hospital. Let's take appearances starting with the plaintiffs.
Greg Anderson and Nick Whitney on behalf of the plaintiffs.
Ethan Shapiro, Howard Hunter, Pat Crowes, David Hughes, joined by our corporate representative, Dr. Tempest Sanchez, for All Children's Hospital.
Several things. First, I know there was a request from Mr. Altenburn for a special jury instruction regarding the violation of internal rule or policy. I've given it some thought. I'm not adverse to doing an instruction, but I think it can be wrapped into the packet as a whole as opposed to doing it now. So I'm not going to give an instruction at this point in time, but it will be part of the
thank you, Queen Olive.
Total package. I have not come to a decision yet between
Lena
your
H,
edit
thank
and
you.
Mr.
3 months.
Elegate's edit, but I know it was just one sentence.
3 words, and I don't care about the 3 words he changed. So.
Well, I was going to say I was somewhat leading towards Mr. Elegate's change. So if you're not opposed, then let's just go with Mr. Elegate's change.
Coffee and Crime just gifted 5
you
memberships
asked
as well.
For reconsideration on 2 issues with respect to Dr. Newberger, and then you wanted to add a third. Let's deal with that first.
Okay, thank you.
Meaning, let's do the 2 reconsiderations, and then we'll.
Right, I don't know if it was helpful, Judge. I sent you just the run report of what's being read in, and it had those. So that you wouldn't have to try
a reconsideration is where they're going to try
but,
again to get the judge to rule in their favor.
So the first one is, this is with the
Tamara Murdag Curran just
March
sent a super sticker with 10.
Tamara, thank you very much
March
for the super sticker.
22 deposition. And it starts on page 11, line 18, as far as the answer. And the question was just, what are your opinions? The specific objection is to his commentary that starting on line 22, backing up, virtually all principal diagnostic medical judgments and decisions to Sally Smith was an intentional act, which was both wanton and malicious. And that goes on to say on line 12, who together agreed to commit an unlawful act and harm other individuals. So we're objecting to the words intentional act, which was both wanton and malicious, and we're objecting to commit an unlawful act. I understand that, his comment, he's previously testified or subsequently testifies about this conspiracy thing, but those are the concerns, Judge. And then there was one other one.
Well, let's deal with this one first.
Sure.
Any response from the plaintiffs?
Your Honor, I have not seen it, but I do remember it. If somebody could read the line.
Here, do you want to share my paper?
Yes, please.
Oh, they're sharing.
Run report from your.
That's nice. How cute.
I emailed last night regarding this.
Yeah, if we get Sally today.
It seems as though she is responding to the inquiry of what her opinions are, or his opinions were at that time there, Judge, and he continues, as the court probably noted in reviewing, to explain why he holds those opinions. Further, battery and false imprisonment would seem to qualify within what Dr. Newberger is expressing at that point.
Judge, I think that's ultimately the jury's determination as to whether or not it was wanton and malicious, or whether or not, and I don't think he's qualified to say whether it was unlawful.
90.704 states specifically that an expert may testify as to any of the ultimate issues in the case.
She doesn't like that. He's spitting facts. Creed, yes, I'm hoping that whoever reads has taken acting lessons. I'd like some motion, some pantomiming, maybe a little inflection in their voice.
This is what we're going to do. At line 22, we're going to redact was an intentional act, which was both wanton and malicious, but we will leave in the prior phrase, virtually all principal diagnostic medical judgments and decisions to Sally Smith. We will also excise, starting at page 12, line 3. This is, by definition, all the way down to line 6, constitutes a conspiracy. So we'll leave in that's opinion number 1. So it will read, I intend to opine that this so-called team represented a group of individuals who together agreed to commit an unlawful act and to harm other individuals, period. That's opinion number 1. the commenting on the deposition and is not appropriate. Okay, so that takes care of your first request for reconsideration.
Yes, there's another on that
Go
same
to
deposition.
page, is it 14?
It is page 14, Judge. And it's line 22. It's in the middle of his answer, which this team cruelly, with no sympathy, with opacity of sympathy. Those are the words that were objected to, Judge, for the same reasons. Improper opinion.
Can I say anything?
Oh, sure, sorry.
They have to be pretty bland about it, but I'm just joking. I want them to take acting classes and hopefully dress up in the part. It's just my sense of humor, Creed. Sorry,
Well, I think
it's going to be
some
pretty
grammar
bland. I
problems
think.
first, but leaving that aside. Well, analgesic medication, and you're objecting to cruelly with no sympathy with opacity of sympathy.
Correct.
I would agree, Judge, to which this team cruelly and with no sympathy, but I think with opacity of sympathy and is non-objectionable. That's a description based on the punitive damages that are in the case. Obviously, we would move to keep all of it in light of the punitive damages, but if the court is so inclined.
What does with opacity of sympathy actually mean?
Well,
I don't
that's why I
know.
don't think
Given
it's-
what he said earlier in the sentence, I assumed I didn't look it up, but I assumed, given what he said earlier,
I believe-
it actually meant the same thing as with no sympathy.
A lack of view of sympathy is, I believe, one of the depositions. Well, a lack of clarity or view of, off the top of my head.
Well, I'm going to strike which this team cruelly with no sympathy, but I will leave in with opacity of sympathy.
Okay.
Okay, and then what was the other one, Ms. Crowell? It was a different deposition.
Yes, Your Honor. The September 22nd, 20 deposition. This one's being read in. We missed an objection regarding standard of care of Sally Smith.
Yeah, I'm on page 150.
150. Here, show you.
I'm trying to look at your notes.
No. Line 4, starting with the word but. He answers the question, by the way, to the contrary, because the question was, are you a CRPS expert? But then he goes on to give an opinion regarding Sally Smith, and given the fact that he's talking about child abuse pediatricians.
Anything, Mr. Anderson? Because I've been consistently excising that type of language from his opinion.
I just missed it, Judge.
As to the deviations of Sally Smith, Your Honor,
Or he's calling himself a child abuse expert, or because it's not an expert on child abuse pediatrics.
May I inquire, Your Honor, is that based on the record in the depositions as to his background training experience? Because he is known generally in publications.
Dr. Newberger, and this is what I was excising from him, and I took out, I think, all of the references, because he kept talking about the dependency court and the concept of Sally Smith doing stuff for the dependency court. So
I'll tell you when you get a break.
consistently have been taking that out. So I will grant Ms. Crowell's motion and remove on line 4, starting at page 150, starting at line 4. But I am an expert all the way through the conclusion of line 7.
Your Honor, can I have one comment?
Sure.
Which is, Sally Smith was, again, the child abuse rotation director within the hospital in her various roles. and described by some of the physicians there as the hospital's child abuse expert. So we think it's a fair comment.
Unless Sally Smith is not going to be allowed to testify in any way, shape, or form that she was a child abuse expert. Dr. Newberger's background training experience far exceeds Dr. Sally Smith's background training and experience in this regard.
But to the extent that Dr. Sally Smith was acting to collect evidence for DCF and the dependency court, there's immunity under Chapter 39. So I'm going to stay with my ruling.
I hope that ruling does not include the period of time between the 7th and the 9th when there was no.
I'm only calling balls and strikes on what was actually presented to me. So
Okay. Thank you, Judge.
I honestly did not read if there was not an objection. I mean, I would have read a couple questions before so I had context, but I didn't go through and read what.
It wasn't even a response to the question, Judge. He just threw it in again.
With Dr. Newberger, I can see how it was very difficult to keep him answering the question.
Hence our request for the court for a bit of leeway with Dr. Newberger. I would have kept him significantly, and I'm sure the court, the defense counsel would have kept him significantly more focused in the answers. The plaintiffs cannot help what happened.
Yeah, it's okay. Let's just kind of move on to the next issue.
He's asking for more time there because of Dr. Newberger.
Was there anything on the exhibit? We didn't need any exhibits, or have there been any further movement on the exhibit list?
Oh, I'm so sorry. Can I have 1 second to tell
Sure.
what needs to come?
Okay, so they seem to be working well together. The judge's chiding from yesterday morning has sunk in, and they're sharing paperwork.
May we inquire from the plaintiff in terms of the order of the witnesses?
Beginning with Jessica Blackrick, the guardian ad litem this morning.
Jessica Blackrick.
And then after that, we would play Sally Smith. I don't believe I wasn't here from the very beginning. I don't believe we have any further revisions to her deposition. The rulings have just made, and then so that would make sense to play her first, and then Dr. Newberger, so we can work on these revisions.
And there was no discussion about Dr. Sally Smith's deposition.
All right, so she'd be second, Newberger third, and then Jack, Kyle, Maya. I don't know what the order is.
I likely will call Kyle, Jack, and Maya in that order.
Thank you, sir.
Okay.
Mr. Whitney, we did have a couple of minor edits that we floated last night.
Question missing here and there.
I sent them to Ms. Lawrence last night. She asked for me to send them over, and I did. It was a few minor revisions.
Okay, so our list today.
I know that we made a couple of revisions at 7 o'clock or so. I don't know if there were more after that.
No, it was just one.
Well, I think I sent two. There was 5 volumes. I think I had one issue on one volume and one on volume 3. But they were all sent to Ms. Lawrence.
So we have
Well,
Jessica
I recall one
Blackrick
was
first.
An objection that was raised last night that was not made to the court or something.
That was
Not Newberger. There was something with Sally Smith as well that.
There was Sally Smith. I believe there was just it wasn't a huge deal. There were a couple of passages of assertion where there was a question missing, or there was context missing.
But got chopped early is what it was. And there was also a couple, and I sent them to Ms. Lawrence again, a couple situations where our light blue counters were not included in the video as well. But we're talking about a couple of things there.
Hey, substantive.
I sent them to Ms. Lawrence approximately 2 hours after we received the final edited version.
Not questioning the timing. I'm just wondering how we deal with it right now.
I can re-forward you the emails to Ms. Lawrence if you'd like.
I think we can make the corrections if they are agreed upon and do it during the witness's testimony. First, Ms. Blackburn.
We'll do our best.
Anything else that you need from me, or are we ready for the jury?
Your Honor, we don't really need to discuss, but to keep in the back of the court's mind before the Kowalskis go on, we had 2 demonstrative aids. One is a photo 2528.6 of Beata as a teenager, previously been submitted. It's for the purpose of damages, and it is not cumulative as to that.
Okay. If we're not going to deal with it right now, then let's not deal with it. Looks like Ms. Lawrence is here now.
Apparently there's a couple of issues.
Thank you.
David wants with this house.
Okay, please say Mr. Anderson won't be reading the depot. I hope he's not. I really hope he's not.
It's just
Because I think he needs to focus on other things.
So we're
good
now?
Anyone can read.
Yes, we're going to make the correction.
Okay. May I bring in the jury?
Yes, sir.
Okay, let's bring in the jury.
We're going to have all three Kalowskis here at one point today, or at least individually they'll be here, probably all at the same time if they're testifying, so to support each other.
I thought you were.
I thought you were what? Why are you whispering? No. All right.
Bring the jury.
Jurors entering.
Whoa. Can somebody give me all the names they know of the defense team so I can make sure I'm getting them right? Got Hunter Shapiro. Is it Cruella or Cruella?
Okay, everyone, please be seated. Good morning. Very loud and energetic. Is that because we're getting close to Friday?
Yes.
He wants tomorrow off.
We thought we could ask.
No harm in asking, right?
Cruella?
Well, I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And while you were not with us overnight, you did not observe any sort of media stories about this case. Is that correct?
Correct.
And were you approached about this case at all?
No.
Okay. With that, Mr. Anderson, or Mr. Whitney, or who?
My name's called Jessica Blackrick.
Jessica Blackrick is our first witness. Tash, so happy you found this community. Overjoyed to spend my days chatting with amazing people. And of course, Recovery Addict's voice is everything. Thank you very much, Tash. I appreciate that. Thanks for the 5 months of support. Wouldn't be the same here without you. The jurors they're so happy to be there. A lot of times you have jurors that grumble and moan, and these ones are like, yay, we get to start again today. We're so excited to be here. Love seeing you all. Favorite part of my day. Good stuff. Who's the defense attorney? Who's the older gentleman in the back that always gets overlooked and never gets time in front of the judge?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Morning.
Morning.
Would you please state your name for the record?
Jessica Blackrick.
Have you been called here this morning to testify as the guardian ad litem for Maya Kowalski during 2016 and the very beginning of 2017?
Yes, sir.
First question is, would you please explain to the jury what a guardian ad litem is?
We are there for the best interest of the child. So in a dependency proceeding, the court can appoint a guardian ad litem where we're not for the parents or for the state. We are an independent advocate for the child's best interest. And specifically for Florida's guardian ad litem program, we're part of a three-pronged team where there's a child best interest attorney, there's the child advocate manager, which that's the role I was, and then there's also a volunteer guardian ad litem.
Is it fair to say that the guardian ad litem, your position, you're there as an advocate for the child?
Absolutely.
We'll talk about some specifics of your interactions with the Kowalskis in the hospital during this time. But before we go there, would you just briefly describe your educational background?
I have a bachelor's degree in psychology, and that's an associate's degree in liberal arts. That's it.
All right, and Approximately what year did you get involved with the Guardian Ad Litem program in Florida?
In 2016.
And how long did you work as a Guardian Ad Litem in Florida?
I was about 6 months. I worked in the Third Circuit, which is Live Oak and Lake City, Florida. And then I transferred to Sarasota in July of 2016.
And you worked in Sarasota and that circuit for approximately 4 years?
Yes, August of 2020.
And after that, where did you move or go to work?
I moved to Waycross, Georgia, and I worked for a domestic violence agency for several years. And in May of this year, I took on the position as program director for CASA, which is, or Southeast Georgia CASA, which CASA is Court Appointed Special Advocates. It's very similar to what Guardian Ad Litem is in Florida. The only difference is we're not, we provide all the funding ourselves, but we follow the similar national curriculum that's called the National GAL CASA curriculum for everything we do.
So, when you were in Florida, you served as a Guardian Ad Litem.
Yes.
And in Georgia, did you take on a more managerial role?
Yes.
Can you explain that to the jury, please?
I'm the program director, so I actually do have some cases where I'm the CASA advocate just because I never want to not be doing that. But for the most part, I supervise the entirety of the program and I write grants so that we can be funded.
With all that in mind, is it fair to say that you've been involved in this type of work, child advocacy, Guardian Ad Litem work, for the past 7 or 8 years?
Yes.
Let's move to your specific interactions with the hospital and Maya Kowalski, Beata Kowalski. Were there occasions on which you supervised phone calls between Beata Kowalski and Maya Kowalski?
Yes.
On how many occasions do you think you did that?
Either 2 or 3.
Have you had an opportunity to review the court order that was in effect for that time frame?
Yes, sir.
Is it your understanding? What is your understanding about who was appointed to supervise phone calls?
Myself and the case manager.
Who was the case manager?
Charlotte Laporte.
And how long did you work with Ms. Laporte?
Well, at that point, since July of 2016, we probably had some random cases together.
All right. So, if I understood your testimony, there's 2 people appointed to supervise these phone calls.
Yes.
Either yourself or Ms. Laporte.
Yes.
Was there ever a time that you would supervise these calls simultaneously? With Ms. Laporte?
No.
Is it fair to say it was one or the other?
Yes, that was the point of adding me, because normally we weren't appointed to actually be supervisors of phone calls. We would just be observers, but the judge in this case did do that.
All right. Did you ever delegate your responsibilities or authority to anyone at the hospital to supervise those phone calls?
Sure. Red flags are waving in the defense's eyes. Did you ever delegate your responsibility? Wait, don't. We don't want her to go there. All righty. This it gets spicy already. So this is an objection. We've got the same court clerk from yesterday who looks just as happy to be here as he was yesterday. I imagine that guy can out-type me any day of the week. Which is why he's there and I'm here. So quick sidebar.
The objection is overruled.
We get to hear the answer. Did you ever delegate your authority?
I'll re-ask the question. Did you ever delegate your authority to supervise these phone calls to Catherine Beatty or anyone at the hospital?
No, sir.
That means she was not authorized.
Let's talk about the phone
to supervise
calls
the calls
you did supervise. Can you explain the framework, the setup of how these phone calls occurred. Where were you? Where was Maya? Where was Miss Beatty if she was involved?
Okay. I was remote in Sarasota and in my car specifically because that was the quiet space that I could find. And I had to call in to these through the hospital. And so it was facilitated through Miss Beatty, and she was with Maya, as my understanding.
All right. So participants on the phone calls then, again, would be yourself, Ms. Beatty, Beata Kowalski, and Maya Kowalski.
Yes.
I'd like to play for you what's in evidence. Have you had an opportunity to review some of these phone calls?
Yes, sir.
All right. We have bits and pieces in evidence. I'd like to play for you what's already been admitted as 2608 alpha, and it's about 1 minute and 10 seconds.
Okay.
We knew that was coming, but it's very important to hear it.
Okay, I'm recording this phone call so everybody knows. Okay, hi, Mommy. Hi, honey. How are you, sweetie pie? I'm hurting. I miss you. I miss you so much, too. I miss you so much every day. Every single day. You know how happy it makes me feel to hear your voice. Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice, too. Yeah. I hope you. What did you say, sweetie? I hope I can see you soon. I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay? Yeah.
We're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Do you remember that call?
Yes, sir.
Oh, was that you interrupting the phone call?
No.
Was that Miss Beatty?
Yes.
Beyond that October 15th call, did you have additional phone calls? Were you supervised?
Yes.
Was Ms. Beatty present on those calls as well?
Yes.
Do you recall from the order any limitation on how frequently phone calls were to be facilitated between Beata and Maya?
Same objection, and also in terms of foundation and time.
Why don't you deal with the time issue, but otherwise overruled.
All right. Do you recall that you supervised several phone calls in mid to late November?
Yes.
All right. The court order in effect at the time, having reviewed that court order, was there any limitation placed on the frequency of the phone calls between Beata and Maya that were allowed?
No.
Was there any limitation imposed on the length of those phone calls?
No.
Did you make yourself generally available to facilitate phone calls as the supervisor under the order?
Yes, sir.
Do you recall a time that Beata had requested a phone call on Thanksgiving?
Yes, sir.
Did you make yourself available?
Yes.
Was that phone call allowed to happen?
No.
Why?
Because Miss Beatty's schedule didn't allow for that.
So Miss Beatty was not amenable to a phone call on Thanksgiving between Beata and Maya?
She just wasn't. It just wasn't in her schedule, from what I know.
All right. Do you recall a phone call after Thanksgiving?
Yes, sir.
Have you had an opportunity to listen to that phone call?
Yes, sir.
If that phone call is allowed to be played for this jury, do you consent to the playing of that phone call?
Yes, sir.
In that post-Thanksgiving phone call, did Beata Kowalski attempt to pray with her daughter?
Object to hearsay, Your Honor.
I haven't asked for it.
Overruled.
Did Ms. Kowalski attempt to pray with her daughter?
Yes, sir.
What was Ms. Beatty's reaction to Beata trying to pray with her daughter? If you could explain that to the jury, please.
Well, the phone call was, Miss Beatty had mentioned that the phone call, it was time for the phone call to end it because she needed to go to a meeting. And Ms. Kowalski asked to pray or began praying. And then at one point it was interrupted by a lot of loud noises. And Ms. Kowalski asked what the noises were. And Miss Beatty said that it was her office stuff. And anyway, she proceeded to finish the prayer, and then the visit ended. And afterwards,
let me stop you right there.
Sorry.
You're doing great. I just wanted to clarify. When you say the visit ended, does that mean that at that point, after the prayer, which was slightly interrupted, that Maya and Beata both hung up?
Yes.
So at that point in the phone call, it was just Ms. Beatty at the hospital and yourself?
Yes, sir.
All right. Please continue.
So at the end of the call, Miss Beatty said to me that that prayer was just the mom's way of extending the phone call. And I said, well, she has a right to pray. And then we were going to schedule, I asked her, can we schedule the next phone call? And Miss Beatty said, no, we're not going to schedule anything right now. I'm going to end the phone calls at this point. I'm going to take care of that.
And as part of your training as a guardian ad litem, do you receive training on the right of families in these types of situations to maintain their religious practices?
Yes, sir. There's cultural competence training that includes all different aspects, including religion. And it's part of our goal as guardian ad litem to make sure that the child is having all of their normalcy needs met, and that includes any kind of religious practice.
And did you inform Catherine Beatty of this, the right to practice their religion?
Yes, it was a quick comment, but I did say, well, she has a right to pray.
And after Ms. Beatty stated to you that she was going to put an end to the phone calls, did you have any future phone calls where you were allowed to supervise Beata and Maya speaking?
No.
Your witness.
Good morning.
Good morning.
Just a few questions for you. So, if I understand, I think I understand, but so the jury understands the rule. The guardian ad litem program is the neutral appointed in the best interest of the child. True?
Yes, sir.
Okay. There's training that you go through. And then there was also somebody who was, I think you said, a volunteer that was assigned as well?
Yes, sir.
Okay. Do you remember who it was?
Yes, Sharon O'Leary Johnson.
Okay. And she would be someone working, is she working under you?
Yes, so I would be her supervisor.
Okay. And she reports to you, well, let me set the preface. I know you and I know what's going on, but I think for the benefit of the jury, let's sort of explain the role. So you would go to the hospital and visit when you could, right?
Yes.
And Miss O'Leary Johnson, as the unpaid volunteer, would also go as well, right?
Yes.
And they would file their observations of what they saw in the hospital in reports.
Correct.
And you would do that as well?
Yes.
Okay. You're not hired by All Children's. You're not paid by All Children's, right?
No, sir.
And you're not paid by the Kowalski family.
Correct.
You're the true neutral.
Yes, sir.
Okay. And not to say you would do anything else, but actually you guys have to sign an oath to the court that you are going to advocate only in the best interests of Maya, right?
Yes, sir.
Okay. And you make recommendations to the court based on what you see as well, true?
Yes, sir.
Okay. So let me ask you a little bit about, have you reviewed your notes?
No.
Okay.
One.
Got it. All right. So if you need to refresh your recollection, let me know. But Do you recall that you first visited Maya at All Children's Hospital on October 14th?
Yes,
Have you reviewed that note?
that's the only note I reviewed.
Okay. If you need me to, would it be helpful to have the note in front of you to refresh your recollection?
Yes, that would
Okay. May I approach, Your Honor?
You may.
And I do have an extra copy for plaintiff's counsel.
Okay, thank you.
Okay. So what I'm going to hand you for the purposes of identification is going to be Defense Exhibit 3250, pages 1 through 4. And I'm glad you have your glasses on because the type print is very small.
I'm actually going to have to take them off for that.
Okay.
Just first thing probably.
All right. Do you want to take a moment to read that one? Would it be helpful before I ask you questions?
Okay, that's fine.
Okay. So this note is computer generated by you, correct?
Yes,
And it shows in here that the date of the visit that you made to All Children's Hospital was October 14th, 2016, right?
yes, sir.
And it says that it was a face-to-face meeting with Maya, correct?
Yes,
And it says that the meeting was about an hour and a half. Is that right?
yes,
Okay. And then you made some notes on your meeting, right?
correct.
Okay. In your note, where was Maya at that time?
She was, let's see. Yeah, she was in her room, her hospital room.
Okay. Did the hospital ask you to come to the hospital and explain to Maya why she was being held at the hospital?
Yes,
Okay. And just for frame of reference, on October 14th, earlier in the day, you were at the dependency court, correct?
correct.
And you made a note that the Kowalskis did not contest shelter at that hearing, correct?
Approach both of you, please.
Okay. They just waded right into the court hearing, the shelter hearing, and started talking about what the Kowalskis did during the hearing. This is not okay. That's why the quick objection just jumped in. They've been steering very far from that, from isolating those two. Oopsies, open door. I don't know. I don't think a door's been opened yet. Well, if they go into it, then the plaintiffs get the right to go into it. That's the point, Beth. If they open that door, I'm gonna have to pull up the Zoom.
Regard
feed.
that last question is not relevant to this case at all.
Yeah, they should not have gone there.
You were asked by the hospital to come to visit Maya and explain to her why she's staying at the hospital. Is that right?
Yes, sir.
Okay. You made some observations while you were at the hospital. Is that fair?
Yes, sir.
Let me ask you about a couple of the comments in here. May I approach on a question before I ask it, Your Honor?
Yes.
He knows he's on thin ice. He's like, Judge, can I run this one by you first before I get myself in trouble? Yeah. So that was a little dirty trick. He got a little bit in. The jury heard the question. They said that the Kowalskis did not object to the shelter at the hearing, something to that effect. But yeah. We'll see what happens. Can I proffer my questions? That's what he's asking. The judge will let them approach 1,000,000 times because he would much rather have them approach and have an issue sorted out before it becomes a mistrial, and so that's why we have all these numerous sidebars. Okay, let's see where are we at. Paste and go. There we go. Open. Again, crank my audio down. Okay. judge is standing, and it looks like, let's see, I forget who's wearing the all gray suit today. Not sure. Formerly known as MD, gifted 1 membership. Thank you very much for doing that. That one went to Courtney Arleo. Sorry. Jenny and GA, welcome to the gallery. Good to have you here with your continued support as well with the Green Courthouse. Thank you so much. The cameras are mostly covered. Oh, we do have... See who I need to see who's wearing what tie, so I know who I'm looking at. I can't narrate this. I mean, I can obviously see the judge because of his robe, and he's got a lanyard. Have you noticed the judge has a lanyard? By the way, I did just see Tayo Toy's a tweet from me about me yesterday, where he mixed in my reporting of the bench conference, my narration of the bench conference to Vogue, the music video. Very well done. Very well done. I very much enjoyed that.
Hey, members of the jury, I'm going to ask that you step into the other room for a few moments. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Okay, so we have a big issue.
All right.
Mr. Anderson is standing in front of he's actually in both cameras. His position is such that he's in front of both cameras, so I get to see both a straight on and a profile view of him. He's wearing the red tie. He's taken off his glasses. Defense has head back to the table. I think they're going to hear this one. We're going to hear this one live. Ooh, somebody's backing up. Backing up.
Okay,
backing
the jury is out of our presence. Ma'am, can I actually have you go sit out in the hall for a few moments?
Here we go. We get to hear it. This is good.
Okay, the witness is out of our presence, so is the jury. Mr. Anderson.
As we explained to the court above, and again for the record, by virtue of counsel having taken a DCF note, held it up.
I'm sorry.
I
know you're not. I'm just moving on so you don't. Sorry, Mr. Anderson. Go ahead.
Mm-hmm. By holding it up, showing it around the courtroom to the jury, referencing it as what it is, and then reading out sections. Admittedly, as we watched, there's some slight paraphrases, but in essence, the language of that note was being portrayed then to the witness. And in that way, the jury is now under the impression that there are notes out there that are contradicting everything the witness says and introducing the whole idea here, the concept of who was in control at what point, which is in direct violation of this court's instruction that we are not supposed to be getting into that stuff. And the plaintiffs have been chastised, and I understand the court's position on those. But in this instance now, we have got effectively a published, or at least part of a published note in here on something the court specifically instructed us, the plaintiffs, and the defense was there not to do. And so we asked the court to take under advisement, because obviously with 5 years into this, we want to see a jury verdict here, but we asked the court to take under advisement a motion for mistrial in that regard. And we asked the court also to consider, if indeed this is the way they're proceeding, and at this point that the door has been opened for us to attack some of these notes and some of these positions and some of these actions that were behind the orders and DCF directions. So that is our position.
Well, let me be, are you or are you not moving for a mistrial? I need a clear, you are or are not moving for mistrial.
May I inquire from the court, if I may move as previously done here, to move for a mistrial, but have the court take it under advisement until the conclusion of the case, because I do not want to take a step right now that wastes 5 years of litigation and now 3.5, 4 weeks.
I am not in the position to give an advisory opinion about what I might do on a motion you haven't made.
Then I cannot make it, because I do not want in any way to have this trial.
So to be clear, you are not moving for mistrial.
Under these circumstances, I am not moving for mistrial. I am, however, documenting for the record that the extent of the damage done here is a basis for it, but I cannot move for a mistrial at this point based upon the circumstances of this case and a disservice to my client after all of this effort. So I just want to say that for the record.
One comment, if I might. There was a representation made to the jury about the Kowalskis not contesting the shelter petition, which is damaging. There was additional representation made that comment was made because something in this note comments on that. I've reviewed the note again. There is no commentary in this note on the failure of the Kowalskis to properly contest that shelter or consent to that shelter, however you want to phrase it.
Well, first off, is this document in evidence?
It is not, Your Honor.
Okay. Let me see this document. Well, just put it. What's the number?
It's Defense Exhibit 3250-001.
I
don't think
that note bigger so I can read it.
I don't think the judge can sanction the defense in this. I think all he can do is say the door's been opened. Mr. Anderson's right to say I don't want to move for a mistrial because he's winning. He's winning this court case right now, right? And leaving 5 years of work and starting over again. That's huge. So the judge, all the judge can do is talk about here. Let me see if I can show you this picture. So if you need a screenshot of everything, all he can do is say you opened the door, and they're allowed to attack those areas, those notes that went to DCFS that originated from the hospital that drove the DCFS decisions, which is huge.
Mr. Shapiro, I thought the question was now, maybe we can have the court reporter ask it again or read it back, but the comment or the question that you asked, which was not, I don't believe it was answered, and then ultimately I gave an instruction for them to disregard, was something about her note indicating that the Kowalskis consented to the shelter proceedings at that court hearing.
I believe I asked, well, anyway, go ahead.
This is very important.
All
eyes
can we
on
have
the
the court reporter read back the question that right before we went to Sidebar that started all of this?
Yeah, give me just a minute. Scroll up there.
We're scrolling. Okay, listen carefully here, guys.
That's why I did.
Defense is worried. Look at their hands clasped. He might have stepped in it. Already working on a strategy for response.
Okay, question. And did you, and you made a note that the Kowalskis did not contest shelter at that hearing?
And you made a note that the Kowalskis...
Was there an answer by the witness?
Yes. At the same time as the objection.
Whoa. Yes, at the same time as the objection.
It was because her note says that she just came from the hearing. I was trying to set the table, and I thought it was because the plaintiffs opened the door to the orders, the interpretation, and the no contact that was entered. That was the purpose for going through it. I will stick my questions for this witness only to their observations at the hospital going forward.
It's too late for apologies here. It's too late.
It's
too late to apologize.
To make that reference, although with the way the plaintiffs have opened the door to this throughout the trial. But all that being said, I apologize for the comment if it was made out of context, and I will stick to our observations at the hospital.
It's sorry doesn't cut it here. Let the judge stew on this. Mr. Anderson shaking his head. Defense is praying that the judge just says we'll call that good.
If I may. Since I don't want to step in any more hot water on this.
He did step in it.
The plaintiff did.
I don't understand how that question was asked based on this note.
I understand.
And given the nature of the defense, let's not talk about the dependency. Let's not talk about the dependency. For years, let's not talk about the dependency. You misrepresent a note on a question that you know can't be asked.
My apologies, Your Honor.
He opened it.
Okay. There's no motion for mistrial. So,
but he opened the door.
We'd like to discuss with our appellate counsel what an appropriate curative instruction would be if we can come up with one.
And also, we were trying to document for the record the seriousness of this. But we're aware of the Second District law on the necessities here. We're in a box. We would ask the court's indulgence to give us the opportunity at some point in the very near future to discuss this with Mr. Tanner, Mr. Elegant, and determine what the best approach is. And also our clients who are not in the courtroom at this moment. At least I don't think they are. And so, but now that the jury thinks that we're consenting to all this, I can't imagine anything more damaging.
Well, I will give you time to discuss with Mr. Elegant and your clients what we're going to do. My suggestion at this point, and maybe you need to take a couple moments, is that we just continue on. Again, to be clear, the plaintiffs have not opened the door by talking about whether there was that delegation in the specific time. I know you disagree, but that's the court's ruling.
I understand.
And you have to live with the court's ruling. So you can't.
I humbly apologize, Your Honor. I believe they had opened the door by talking about what the order said, who was responsible, who was allowed to contact who. But I apologize.
As a reminder, I mean, and I know you weren't there for so many of the hearings, and you kind of came in to this late, but we always talked about, before you do something that is possibly out there on an edge, come talk to me ahead of time.
I said, the judge, it's like, my door's open. My door's open. We just lost a feed. Hang on one second. We're going to switch to a different feed.
I agree, and I did it the second time. So before the witness comes in, just so I don't step in it again, there are 3 notes written by the guardian ad litem regarding their observations of Maya at the hospital. May I inquire of this witness what the observations of the guardian ad litem were? And then at the end of
Absolutely, at the hospital, sure.
Yes, and then just again, so I'm approaching this, I'm treading as gently as I can, Your Honor. At the end, there's a guardian ad litem report to the court. Can I phrase my question in terms of, well, let me ask Your Honor this. There's
report to the court.
The report is titled Recommendations and Observations of the Guardian ad litem.
Do you want to start talking about the dependency action? Does the defense want to talk about what happened in the dependency action?
No, but that's why I'm asking you. Can I ask this witness about what the only the part about in the report, and I'm happy to hand Your Honor a copy, because again, I want to make sure I don't. And there's an extra copy for plaintiff's counsel. There's a section on
Can we put this up and just
yeah, sure. It's Defense Exhibit
3258-0001. 3258-0001, and this is not in evidence?
No, Your Honor.
Okay, and what provision do you want me to look at?
Section 3, Observations of the Child.
Can you make that larger?
But no, the fact this is a report to the court. Man.
Okay. This looks like an observation that was made at the hospital.
Correct, Your Honor.
I have no problem with you asking what this witness saw, what she saw of Maya at the hospital. If she doesn't remember and she needs something to refresh her recollection, certainly you can refresh her recollection with this, but it's not going to be shown to the jury.
I understand, Your Honor. That's why I brought extra paper copies.
Well, Your Honor, This is a pleading to the court. We previously had a lengthy discussion, and we have a motion pending for reconsideration of the BD email, which was not even to the court. It was an internal email with recommendations and observations, and that evidence was excluded. And so we have to object because now they're allowed to put an observation.
Mr. Winnie, you're misunderstanding what I'm saying. For purposes of refreshing someone's recollection, pretty much almost anything can be used.
Understood.
And if this, you'll call it a filing in the court file, if this filing helps refresh the witness's recollection, assuming she needs it, she might not need it. Assuming she needs it, then that's fine, but it's not being shown to the jury. It's not going to be referenced to the jury. It's just the document that she's using to refresh her recollection.
I understand.
So,
as long as they're not waving it around and keep it away until.
As long as they don't wave it around.
I mean, that's. You were making statements that Mr. Shapiro was waving the document around. I disagree with the characterization. Mr. Shapiro was standing at the lectern asking questions presumably from the document. He was not showing the document to the jury, and frankly, given how small the type is, and the distance from the lectern to the closest juror, even if he was holding it sideways.
It's not that they saw it. It was the insinuation that it was in there.
I don't think there's any reasonable belief that the jury would have been able to, with that much acuity, figure out what the words on that page were.
And I tend to agree with the court that unless we have falcons in the jury, they're not going to be able to spot that type. The one thing that I was concerned about, and I agree with virtually everything the court said, except he was holding a paper up here like this at the time that this started.
Standing at the lectern.
Standing at the lectern, but holding a piece of paper and obviously looking down, looking back up, looking down, looking back up. It does not take much to discern that this was some sort of official document, official report, because that's the way it was introduced. And so it appeared, to me at least, that he was holding it, reading off of it. He did set it down then, just for the record, and I think that implies to the jury that there is some official document out there that this witness drew up or submitted to the court or to DCF, but in some way this was something official rather than for the use I understood he was starting out for.
Well, I think we just need to move on. I will give you time.
Recap's going to be
discuss
great.
With your client and
Rob's going to have a heyday with this one.
So by the time we're finished with lunch today, I want to know whether you're moving for a mistrial or not, if you're asking for a further curative instruction or not, and what that is. If there's going to be a curative instruction, please get Mr. Altenburn and Mr. Elegant and Altenburn together on it, and we'll address it after we come back from lunch. Okay?
I have one more comment, and it's based on the allowable questioning that's coming.
Don, welcome to the gallery.
You were just a moment ago told there were 3 notes by Jessica Blackrick.
That's not what I said.
I'm sorry if that's not what you said. Well, I would object to questioning because there's 5 notes in total, and 4 of them were authored by Sharon O'Leary Johnson, who she just testified was the volunteer guardian ad litem, not Ms. Blackrick. So if he's going to be asking questions about personal observations at the hospital of Ms. Blackrick, fine, but I don't think it'd be proper to ask Ms. Blackrick to comment on what Sharon O'Leary observed in the hospital. If they want to call her in their case to have Ms. O'Leary Johnson comment about her observations, fine, but I don't think that's appropriate for this witness.
Well, I'm assuming we're not moving these notes in.
I'm not, but Ms. O'Leary Johnson reports to Ms. Blackrick, and these reports are filed with her. I believe I should be able to ask her, were these the observations of Ms. O'Leary Johnson of Maya at the hospital as reported to you?
Keshet, thanks for gifting a membership. Charlie Raven, good to see that courthouse color change next to your name. Thank you so much.
Exception that applies.
What's the hearsay exception that applies? to this document?
She would sign off on these as her supervisor at the end of the case.
That's not a hearsay exception.
No, you can't. If you want to get, is it Miss O'Leary Johnson? It's observations, you can call her.
Mm-hmm.
Okay.
Then the observations of the child, then I'm going to be relatively brief with this witness, in this report are signed by her.
Who is her?
Miss Blackrock. And I'm trying to tread carefully without mentioning this is the report to the court.
Did this witness lay eyes on the child on, was it the 4th of January?
It was the 14th of October, Your Honor.
I think the note that I was looking at talked about January 4th.
The report to the court, yes.
Let's make it easy. You can ask about what this witness saw when she was in the hospital. But if someone else told her what that other witness saw, you can't ask this witness about what someone else told her what they saw.
Yeah, I understand that there'd be a way to get that testimony in through her, but I'd have to move the notes and evidence, which I can't do right now. So we might just do it through O'Leary Johnson. I understand, Your Honor.
Well, the court will, maybe we ask at this point, although we'll need a curative instruction or the alternative, that at least at this point that the jury be instructed to strike the question is stricken and any response should be, I don't want to draw more attention to it, Judge.
Well, that was exactly what I was thinking. I already told them to disregard the question, and I said it was not relevant to this case. I already said that, and that was immediate.
Yes.
If we're going to do something else, and I'm not saying we are, I'm just saying if, I only want to do it one more time.
Sure. Got it. I agree.
I don't want to keep doing 2 or 3 instructions on something.
In retrospect, I do agree with the court on that. I don't want to emphasize it anymore.
Okay. We ready to bring the jury back in?
1 minute, Your Honor, please.
Do you all need to take a couple minutes before to regroup? Mr. Shapiro?
If you don't mind.
Let's take a 5-minute break.
There needs to be an instruction.
All right, scores in recess. What do you got?
Crazy. WD-40 needed on the judge's door, please. Squeaking. All right, so what happened there was Mr. Shapiro, in his line of questioning, using a note, a record that the witness had either drafted or had been using in her line of work as a guardian ad litem, asked her about the dependency hearing and if she was aware that the family had not objected to the shelter order at the hearing. And the witness said yes. At the same time the witness said yes, Mr. Anderson was yelling objection, which the judge upheld and said, yes, that you can't go there. And then they said to strike that, and then disregard that from the jury. The jury heard it though. And it's fairly detrimental to the jury, to the plaintiff's case, because it makes the family appear like they were party to this event and willing participants in Maya being kept from her family, that they were okay with it, which obviously is not the case. But the way the question was asked and the way it was thrown out there, the judge took issue with the fact that Mr. Shapiro asked the question and even referenced the note in the question, which there was nothing in the note about that. And Mr. Shapiro has come hat in hand to apologize for that and said, sorry a million times. But he got it out. He got the answer out. The jury heard it. And the judge keeps mentioning the words, open the door, open the door. Mr. Shapiro, in his apology, he says, even though I think the plaintiffs opened the door, that's why I went here. The plaintiffs, they keep going here and opening the door. And the judge is like, we've ruled this. They didn't open the door over and over. I've said that the door has not been opened. You can't go there. And we haven't. And he's like, well, I only asked the question because I thought they opened the door. If he thought the door was opened, is not the door opened? Is not the door opened now? Can the plaintiff now walk through that door and say, look, this is out there. Let's talk about the dependency hearing. Let's talk about the notes that went to that court and where they came from and when they came and what the hospital said and what drove the decisions in the dependency court and who was really behind this. And suddenly all that guilt and fault that's wrapped up in that dependency court, which the hospital was hiding under that umbrella from, it becomes a lightning rod instead of an umbrella. And they suddenly are, on the hook for the behavior that happened there as well. So I'm blown away. I'm astounded. First of all, I wonder if the Kalowskis at this point will call for a mistrial. That still is on the table. It hasn't been done right now. But Mr. Anderson did this before, and the judge told him last time as well. You can't say I'm going to reserve the right for a mistrial later. It's like it's either you do it or you don't. Right? Don't waste our time. I can't tell you that, go later on. Later on you can say, oh, mistrial. Oh, yeah, back. You didn't like the way it went? It's fine. No, it's a now or never type thing. And so he's like, well, I can't throw away 5 years of work that got us to this day. And it was work to get to this day. This is, many people thought this trial would never see a courtroom. Many people thought, the hospital would just bulldoze over the top of this family and no one would know about it. Wow. Melanie says this has been one heck of a trial. Thanks for covering it. Thank you, Melanie. It definitely has. Let's see. Did any other questions? So I can scream in my office for a minute. Yes, the judge is like, I need a break. Yesterday, he was yelling into the wall. He was probably hitting. He's probably got a punching bag or something in his office that needs to be replaced because it's been used so much. This is just crazy. It was a huge mistake. I said he stepped in it, and Shapiro himself says, so I don't step in it anymore. And he says hot water. I think it was a lot smellier than hot water they was stepping in. But he knows he tread where he should not have trod. This was a big deal, and I don't know. I think, in my mind, I think Mr. Anderson, instead of dangling that mistrial carrot, which we know that defense has asked for a couple times already, and they probably are looking favorably on, thinking, hey, maybe next time we'll get some better rulings. Why not push for that open door? Why not, if you see daylight through that door as it's opening up, why not say, Judge, I have to go there. I cannot leave that. You can't just say, ignore that. I have to address that. I have to address these notes. Now they've tainted the plaintiff so badly by their allegations, their statements, their questions, and the answers they've solicited from the witness, which the court has ruled is not acceptable. Now I have to go in there against my wishes. I don't want to do it, but against my wishes, I'm going to have to go in there just to set the record straight and balance this all out because it's not fair. So I'm surprised he didn't push more for that because I don't think the mistrial is the threat they want it to be for the hospital. The hospital can wait this out. The hospital can fight. I don't think the Kalowskis and Mr. Anderson and Mr. Whitney are in as good a shape to wait this trial out and set it out in another 5 years. Oh, man. Princess Buttercup comes in and sends a super chat, says, bite me, played a mean trick on me yesterday, contemplating my revenge. Princess Buttercup made a trip to the vet yesterday, and not very happy today, how those things go. All right. Wow, spicy day. I'm glad you're here. This is what we're here for. This is just incredible. I wonder what the two sides are working out as they try to address the issues. What's that? Oh, my wife says be big like this. When I'm talking, I'm supposed to be big like this. Oh, but now I'm blurry. All right, now I'm big. But now I'm done talking, and now we're waiting for court. So hold tight. We're gonna get back to court. The audio is still on from court, so we'll hear it just as soon as it happens. Let's see. Actually, we want this one right here. Different audio. I still look blurry. I don't feel blurry. Do I look blurry to you guys? I have the L in the wrong place. Which L are we talking about? Listen to learn. I don't know. I will listen and learn if you will tell me where the L is. I'll try to get it corrected. Let's see. Courtney Arleo says, I wonder if Jules can tell us when the jury comes back in, they immediately start writing notes, or if so, they definitely heard it. Do you think the defense could have said it intentionally to get a mistrial? Possibility. Sorry, thanks for coming in. Appreciate that. Anything else? Let's see. Elizabeth says, it's so much better to watch these trials with you and everyone. It's not so lonely. Thank you for covering it. Thank you, Elizabeth. Thanks for being here. Appreciate the comments and the companionship as we watch this together. Unpaid caregiver says, Joni, 100%, where is the judge yelling at Shapiro? I'm so upset with this judge showing extreme bias toward defense. I don't see that. He's been frustrated at different times, and because this is the plaintiff side of the case, a lot of the things that are being done are done by the plaintiff side. I think once it switches to the defense side and we start getting objections from the plaintiff side, I think you'll see that balance out. And I think his rulings have been mostly, I would say, fair, have been very fair, in that I believe that in Florida specifically, and maybe nationwide, the laws regarding medical malpractice are very friendly to the hospital. And it's the laws that the judge is weighing all these objections and rulings on. So I think, yes, the hospital does win a lot of objections, and it seems like an uphill fight for these plaintiffs, which it should be. They're the ones alleging the other side did something wrong, so they have to prove that. But I think the judge has been pretty fair on this one. Goodman Law, Nicole says, I'm disgusted defense did that on purpose. More angry, the judge allowed it without any consequences to the defense counsel. Oh, man. Yeah, that surprised me, that he thought, where he just says, if we just move on, it won't be a problem. Okay? As long as no one points out the fact that we just hit a bump in the road, no one's going to be like, whoa, what was that? But we hit a bump in the road, and I think everybody felt it. I think just moving on does not make it not happen. I think the jury will not really know what just happened, since several of us didn't know until we explained it, says Connie. Connie, you might be right. And that's what the judge is basically saying, I don't want to make it a big deal. If we go back and say, hey, I told you to disregard the last remark, don't remember anything about the court and what the family did or didn't do, and the jury's minds are like, what just happened? And this will be playing over and over in their head. And he doesn't want to do that. He says, if I have to go back one more time, that's it. All right, we're going to, I think we're still at break. Judge is still gone. Let me show you where we're at. Right there. There we are. Yes, I'm sorry, is keeping him on his toes. I need to keep notes about this one. This is crazy. So this is in Jessica Blackrick's testimony in the Shapiro Cross. Can't believe he literally included the dependency hearing in the question. That's what blows me away, that Mr. Shapiro, after all this, and have their whole, we're sheltered, we're protected, we can't go in there, the plaintiff can't even talk about this. We can't even talk about, as Mr. Anderson said, we can't even bring in evidence of an internal email within the hospital that eventually went to the dependency court. He says that was ruled. We can't even go into that, in that internal document between two hospital employees. Okay, we can't go there. And now here you are bringing up dependency court rulings and notes. Yeah, I side with Anderson on this one. It's a little appalling. And yes, they're not trying to admit this note. That's a little different that way, where the plaintiff was trying to admit that email. But jury's heard it. Yep. It's too late. Cat's out of the bag. You know what would be amazing? What would be absolutely amazing? If the juror questions at the end of this witness go into that issue. If the jury points out that not only do we know it, we're thinking about it, we have questions about it, this is playing in our minds, that what exactly happened here? Why did you not, why are we not supposed to know? If they ask questions about this, does that cause a mistrial? Or does that mean that's just proof the door's been opened? Oh, man. Okay. I'm going to take some deep breaths, get a drink out of my mug. That usually calms me. Get some nice Deer Park water. A lot can sweep under the rug in a court case, especially in cases where they're sort of monotonous and everything sounds repetitious, even though it's a little bit new and a little bit different, or maybe from a different angle. A lot of the testimony will be like, yeah, we know this. We've heard this before. We're just getting a different person to nod at the right appropriate time. So there's a lot that can happen if there's a mistake that can be like glossed over and be like, hey, sorry, made a mistake there. We'll just continue. I don't think this is one of those. I think it's too big. Judge needs to allow plaintiff to ask if defense counsel misrepresented Laklowski's acquiescence to the shelter order, and they vigorously fought it. Judge is coming back. Let's see. We're waiting for the live stream to catch up. The Zoom, I'm seeing the judge is back on the bench, and the jury's coming in. So I think we're moving forward. I'm not sure if he's going to address this one more time or not. Let's watch for that door opening any second now. And 3, 2, 1. Open the door, Judge. I did the countdown and everything. There it goes. Okay. Here we go.
Let's bring in the jury.
Bring the jury. Judge does not sound happy right now. The question would not be answered. You're right, Original Sin. The question would not be answered. It would not be asked.
I've got the jury coming in.
But the fact, if the jury asks a question about that, it will mean they heard it, that they know what's going on. They're thinking about it when they shouldn't be. It shouldn't be something in their head. I think we're just moving on.
Get the witness back, please.
Somebody get the witness.
Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information about this case. Is that correct? Correct. And that you have not been approached by anyone about this case. Is that correct? Correct. And that since you were last with us, you have not seen any media coverage about this case. Is that correct? Correct. Okay, thank you very much.
If I may proceed, Your Honor, my sincere apologies. I just have one more question for you at the bench. If I may.
Judge is like, I said you could approach. Come on up. Come on down. Let's see. Jury's there, so white noise is on. We're not going to be able to hear this. I can narrate if you want. Mr. Shapiro, obviously, at the front. Looks to be a quick question. They're already headed back on the Zoom, so we've got about 10, 15 seconds here for the live stream to catch up. The judge wants this. The judge would rather have 50 of these every day, of everyone approaching and asking the judge at the bench something. A little bit of a shake of the head from the judge. So I'm not sure if he's agreeing with whatever Shapiro has in mind. Okay, he says go. Go and do your thing. Get back to your places.
I don't have any further questions, Your Honor. Thank you.
Yes, I'm all done. I'm just going to be wiping my shoes off and hosing down my pant legs to get the smell off me.
When you went to the hospital, did Ms. Beatty ever introduce herself to you?
No, I never met her in person.
And so when you were there as the child's advocate, Ms. Beatty was not around?
Correct.
No further questions.
Any further questions?
No, Your Honor.
Members of the jury, do you have any questions?
We do have questions. This is the moment.
Okay. If the attorneys can approach.
I think it's just a couple questions here, not very many. The judge has not asked the jury to leave, and usually he asks them to leave when there are a lot of questions to discuss. Judge is reading the first question, hands the paper to Mr. Anderson. Looks like there's a second sheet as well, possibly. Let me see. The judge has something on his. The judge is looking down at his desk. He gets the first paper back. It might just be the one paper. He stands up now, still holding the questions in his hand. You hear an argument from the two sides who have positioned themselves, so we just have gray suit and blue suit visible on the Zoom. Not a single question on the Kowalskis fought the dependency order. You've got to be kidding me. Apparently, Nicole, the door is not opened. The door is not opened. So he gets the paper back. I forgot that you guys can see as well, but you're like 15 seconds behind Zoom. Let's see. Yesterday, Jewel said yesterday plaintiff is not getting paid for this on contingency, so I think defense could be trying to bankrupt him, causing a mistrial, and have to start over. Yeah, CG, it would be okay. The plaintiff, there are people on the plaintiff side that are getting paid, right? The firms that are either it's a single firm or joint firms, whoever's the co-counsel, those firms are paying their paralegals. They're paying their staff. They have been for 5 years. They've been, there's an outlay of money that's been going on with this trial. Just as it has been on the other side as well on defense. But the difference is the defense counsel, they've been getting checks from the hospital, right? They're paid up. Okay, there's just like, they're going to keep billing and they just keep getting checks. They've been paid these 5 years. Mr. Anderson and Mr. Whitney have not been paid by the family. They are working entirely on contingency, meaning that if we do not win, we do not get paid. But they've still paid all their employees. They've paid all those fees. It's huge. Goodman Law says, I need a breather. The plaintiff has blown this case big time. I'm so pissed I need to walk. Be back in a minute. Nicole, it's frustrating. It's frustrating. I don't know. Here's what I think. Okay, and this might be a strategic move down the road. We might look at this and say we're so glad they didn't move for a mistrial in that moment because they had this in the bag. It's interesting. Yeah. Can the judge declare the door open on issue, or does one side have to ask the judge? The judge would have to address it.
Shapiro himself said he thought the door was open, so I would love to hear argument on that with Shapiro doing the talking.
Yes, well, Mandy, he's gonna argue that the door was opened by the plaintiff, by what they've done, and the plaintiff has been cautioned several times not to go into an area, and they've objected. So this has been both sides that have been in this same situation. But if he said he thought the door was open, that the judge would rule on that, right? The judge would rule that the door has been opened on a topic like that. You can't just go into areas where the judge has said you can't and then say, well, judge, I thought the door was open, which is what he did. Mandy, by the way.
Funding for sending Judge Carol Stevens hot chalk and SMBP, please, Daddy RA.
Maisla. Startup funding for sending Judge Carol Stevens hot cocoa. Judge Carroll wants Stevens hot cocoa, spicy maple bourbon pickles, and possibly a Snickers. Possibly a Snickers bouquet. Thank you, Maisla and Mandy Strong, both for the super chats. Appreciate that, both of you. Filing fees alone would be astronomical with all the filings in this matter. Yeah, I don't know what the fees are in Florida, but if you've got tens of thousands of pages of documents and motions and everything else, the court is not cheap. Anderson didn't live in that area. Are they from Florida? I don't know if he's from Florida or not. She did say he's from out of the area, so he's obviously probably taken up a temporary residence here for at least the duration of the court, and probably visited here a lot as well. Good question here from Dean Sparks, probably from Mexico. You still in Mexico, Dean? Is that where you're at? Goodwin Law says, is it your sense that, or he says to Goodwin Law, is it your sense the judge would have granted a mistrial if requested? I don't know. I'm not convinced that he would have. Only because it's been back and forth, and both sides have broached this. This seems to be one of the more egregious broaches of the court's order that I can recollect in this trial, specifically regarding the dependency hearing. So maybe, but I just think back to other cases where we've had judges who literally are scratching their head. Think of the Anderson trial, Zachariah Anderson, where the judge was like, how do we avoid a mistrial right now? Literally, these words were, spoken in open court. It's like, I'm not sure how we can avoid a mistrial, but they did. They avoided mistrial. We haven't had that from the judge here, where the judge is talking about mistrial. He's talked about opening the door, and I think he would much sooner get to the point where he opens the door on that topic and allows the plaintiff to bring in that first layer of notes. Obviously, the judge is not going to say, fine, all dependency stuff is on the table, bring everything. We will relitigate the entire case. He's not going to say that, but he's going to say, you guys open the door, and that first layer of notes that from the hospital to the court before the court made the ruling, right? Those are the ones the plaintiff wants. That first layer of notes, that's fair game. That's going to be the ruling if he does rule that it's allowed in. Plaintiff attorneys are from Jacksonville. Thank you, Just Crystal. Appreciate that. Or Just Crystal, are you in court today? I'm not sure. I'm not sure if you had an opportunity to go back. And thanks, by the way, for calling in the other day. We appreciate that. We've had both Jules and Crystal in court. I think we're about 20 seconds here from the sidebar being complete, talking about the juror questions. A lot of deliberation about these questions. So you're going to hear those in just a second, as the Zoom's already begun. They're asking the questions right now. Turn this down just a tiny bit, because you guys can't hear that. Sorry. Judge's rule.
Okay. Members of the jury, most of the questions that you presented, I'm not going to be able to ask. But the question I can ask is, ma'am, the jury wants to know, was Miss Beatty always listening or included in all your calls between Maya Kowalski and Beata Kowalski?
Yes, sir. She was the point of contact for scheduling and facilitating the phone call to happen, and she was on it the entire time.
Okay. Thank you. Mr. Anderson, anything further? Or, sorry, Mr. Whitney, I apologize.
No, nothing further. No, nothing further.
And may this witness be allowed to go back to Georgia?
She can, although we'd like to not fully release her.
Thanks for your great coverage.
So the answer is yes, you can go back, but at some point you might have to come back. So, but the lawyers will be in contact with you about that, okay?
Okay, thank you.
Thank you. Have a safe drive back.
Driving back to Georgia.
Mr. Anderson, Mr. Whitney, your next witness, please.
All right, Dr. Sally Smith by video deposition.
Sally Smith, here we go.
Okay.
And just to inform the court, I'm told there's 5 different tapes. We'll have some breaks here.
Okay. Watch this.
Buckle up. Okay, Angie Childress, thank you very much. The judge has a light switch routine down pat. Looks great.
Alexis, 20% down, 20% up. I went to school for that.
Judge has all the jokes. Angie, thank you very much for the super chat.
Just don't ask me to turn it back on.
This is going to be crazy. Get your notepads out, and when you have questions, during the breaks we're gonna go over your questions. That was fast. Okay, I'm going to move out of the way so you can...
Would you raise your hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
She almost
Sally Marie Smith.
And you were a pediatrician working for the state in the case of Maya Kowalski. Is that true?
I was the medical director for the child protection team, providing a medical evaluation for Maya Kowalski, yes.
Following medical school, what did you do?
I did a pediatric residency. I did a 1.5 years of residency training at All Children's Hospital in St. Petersburg from 1984 to the middle of the end of 85. And then I transferred back to St. Louis University at Cardinal Glennon Children's Hospital, and I did the remaining year and a half of my pediatric residency there and completed that in 1987.
In your residency program, how long did you spend, and you rotate through a number of different areas, do you not, in your residency? All right. How long did you spend in pediatric psychology or psychiatry?
I, again, did not look at my transcripts before I came here. I really have no idea specifically. I'm sure we had training in pediatric psychology and psychiatry as part of multiple components of the residency program, but I don't specifically remember like how many weeks or if I did a specific rotation or something like that.
Okay. And do you remember any of your professors, or I guess they're doctors that are also adjunct to a medical school that you were working with? Or were you just, I'm trying to figure out the setup there. And my question really is, were there any doctors who are also professors that specialized in pediatric psychology or psychiatry that you worked with over this residency?
I don't recall.
Okay. Okay. After your residency, what did you do?
I did an additional year of fellowship training in ambulatory pediatrics at St. Louis University, Cardinal Glennon Children's Hospital.
What is ambulatory pediatrics involved?
It was fellowship in, ambulatory is people who are not hospitalized, essentially. And so I worked in clinics with various mentors, learning to essentially teach academic pediatrics in the clinic setting. I don't recall if I did any specific inpatient work as well.
What is academic pediatrics?
Pediatrics that is sort of focused on education and training of medical students and residents and interns, and in many programs in academic medicine there are also research components to the work.
The past 17 years you've worked at Suncoast Center in one form or another, correct?
I don't believe so. I don't think that the Suncoast Center has held the child protection team contract that entire time. There was another agency called Help a Child that held the contract from the Department of Health when I initially became the medical director. I've worked with the child protection team since 1990.
Okay. So when it says medical director, Suncoast Center, child protection team, were you working for Suncoast Center from 2002 to the present?
I've been the medical director of the child protection team from November 2002 to the present. It probably should actually say Department of Health rather than Suncoast Center, because Suncoast Center is just the agency that holds the contract.
Okay. Well, Suncoast Center started at ACH in 1979, did it not?
No, that was the child protection team, not the Suncoast Center. I'm going to guess it was around 2007, 2008 that the Suncoast Center took over the contract for the child protection team, but I don't remember exactly when that was. I'm not sure, sort of what corporate name was, assigned or that kind of thing. When I worked with the child protection team in 1990, it was, their signage and things said Suncoast Child Protection Team.
Okay. Well, when did you return to All Children's Hospital after, I think you were at University of Medicine and Dentistry of New Jersey, New Brunswick, New Jersey, from 88 to 90?
Correct.
And then you were back at All Children's Hospital, it says a staff appointment from 1990 to present?
No. Well, my active medical staff, yes, has been 1990 to the present. I was employed by the hospital from 1990 to 2002.
Okay.
In the general pediatrics division.
So you went residency for a period of time, then you left, then you came back and started with ACH?
In 1990, when I moved back to Florida, I took a faculty position with what was then All Children's Hospital, yes.
Okay. Would you agree with me then that you do not hold yourself out as an expert in pediatric psychiatry?
No, I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychology?
I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric neurology?
No.
I mean, you're agreeing with me.
I do not.
Would you agree with me that none of these, none of your training has involved an in-depth analysis of the diagnosis and treatment of RSD or complex regional pain syndrome?
I agree.
Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. You see that?
You're asking me if it says that?
In Maya Kowalski's case, was the medical director's opinion, was that you, or was there somebody above you, a medical director, whose opinion you could seek? Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. You see that?
Yes, I see it.
I mean, who's the medical director there?
That would be me.
Okay. And then the statewide medical director's opinion.
Yes.
Was that ever, in Maya Kowalski's case, did you ever seek the statewide medical director's opinion?
I did recently, but I don't recall if I did at the time of the evaluation or not.
Tell me about who that was recently, or is recently, and what opinion you sought.
Dr. Bruce McIntosh reviewed the file. And I didn't personally seek his response.
Let me find your report here real quick. Page 8?
Yes.
All right. So, Johns Hopkins All Children's electronic medical record. What does that mean?
Well, as an active medical staff member for Johns Hopkins All Children's Hospital, I have access to the electronic medical record. So I reviewed that, many documents from that medical record in compiling my report and reviewing the case. I did not print everything, so what you received of my medical records that have Johns Hopkins All Children's headings on them would be what Dr. McIntosh received.
All right, so Dr. McIntosh, according to you, received the medical records of Dr. Kirkpatrick, is that right?
Yes.
Dr. Hanna?
Yes.
Is that right? Dr. Barr? Is that right?
Yes.
Dr. Wassenauer? Is that right? He did not receive records from Dr. Chopra? Is that right?
Not to my knowledge.
Or Dr. Cantu?
I was never able to obtain records from Dr. Cantu, so I don't have them and did not have them to provide to him.
And so you were familiar with the fact that Doctors Hanna, Kirkpatrick, Barr, and Wassenauer all diagnosed or concurred with a diagnosis of complex regional pain syndrome, right?
This is the gotcha question.
That appears to be correct.
Tell the jury whether you believe that every mother that fails to remember to tell a new treating physician the entire medical history is committing an act of child abuse?
No.
Tell the jury whether you believe that every mother that fails to follow the directions of the doctor or the prescription to the letter is committing an act of child abuse.
No.
But in this case, you believe that Beata was.
Upon review of all of the extensive medical records, review of all of the observations of the child in the hospital, review of the, let's say, unconventional treatments, including hyperbaric oxygen treatment and high-dose ketamine treatment repeatedly, it was my opinion that there was ample evidence to support a diagnosis of medical child abuse. And it appeared most likely that Mrs. Kowalski was the primary one who was resulting in, or I don't know what the term is, it's not probably instigating, but initiating or whatever, the child abuse. Perpetrating the child abuse, let's put it that way.
Just the prednisone issues, the stuff we've been going over the last hour. Do you think that was an act of child abuse?
There was an element combined with everything else of child abuse in the prednisone utilization and administration to the child, yes.
Other than this case, have you ever testified in court or by deposition in a case involving CRPS?
No.
That was disc 1. Disc 1 is complete. It's a 5-disc set. So hold tight. We're not going anywhere. Do we need a break, Judge, or are we good? It's 10:30.
Expert in pain management?
No.
Okay. Did you ever have a conversation with Dr. Kirkpatrick at any time in 2016 in which he offered to have you come over to his office and he would demonstrate to you with Maya or with another patient the testing that could be done to objectively determine the degree of pain a patient was in?
No.
You never talked to him about that?
No.
Okay. Did you have a conversation with Dr. Kirkpatrick in which he told you not to move forward with Munchausen by proxy or another allegation of child abuse?
I do recall that he made some such recommendation to me. I don't recall the exact words.
Did he express to you that there was an organic basis for this child's pain?
I don't remember specifically that he, spelled that out. I remember, at least in general terms, that I asked him about incongruities in the child's presentation, and he reported that was a manifestation of allodynia prior to touch, conditioned to expected pain from human touch, and that there was a fear of pain component that explained the child's way that she was moving around and touching things and doing things, but then couldn't do those exact same maneuvers when a physician or a therapist asked her to do so, or things were touching her skin, and then when somebody had a light touch on her skin, that she would scream in pain when a similar amount of touch was not triggering that kind of response. So I remember that he and I had some discussion about that phenomenon. A fear of pain component can be explained, and therefore it was my impression that he was telling me that information as a way to indicate that there was no other possible diagnosis in the case, perhaps.
That was disc 2. Hope you liked that one. It was a short version, but apparently the tech guy was still learning how to hit the record button during this deposition, but he'll get his act together. We're going to start disc 3 here in just a minute.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Did Dr. Kreisman, a physician at
Jump
Johns
days.
Hopkins All Children's Hospital, examine Maya and note that she is not in any pain?
That was his assessment that day, yes.
And that she is not moaning, she is smiling, she is interactive, she is very engaged. Is that what he found? Is that what he found?
That's what he has documented in this note that references his examination of her when she was at his office on May 11th with her father.
And at the bottom of that narrative, he says extremities show no clubbing, right?
That is correct.
What is clubbing?
So that is an abnormality of the distal fingers, essentially the area of the fingernails where the nail bed gets enlarged, and the fingernails often have an enlarged size across the tip of the fingers, typically related to chronic hypoxia or respiratory insufficiency.
It's also a specific symptom of RSD, complex regional pain syndrome, is it not?
Not to my knowledge.
Okay. But you're not an expert in it, right?
I'm not an expert in complex regional pain syndrome.
And then he says she moves spontaneously in her wheelchair without incurring pain, right?
Yes, as was observed on other occasions.
Do you consider tachycardia to be an abnormality in a child this age?
It can reflect many, many different conditions in the child.
Well, what is tachycardia?
A fast heart rate.
Okay. In last deposition, you said that a fast heart rate would be an indication of somebody being in pain, right?
It could be.
But you put no abnormalities noted on her exam. That's not really true from the actual record, is it?
Again, you probably should ask the person who made the documentation. They may be referencing that contrary to most cases of complex regional pain syndrome, she did not have any color change of her extremities, sweating abnormality, deformity of her extremities that would provide objective evidence to support her reported diagnosis.
Let me show you what has been marked as Exhibit Dane.
Trying to find a date on this. 10/7.
And I'll reference you to, and I folded it over, the physical examination found on page 6 of 9, which is PLT 4074, and I highlighted under cardiovascular. Can you identify what that is first? What 15 is?
So this is the emergency center physician notes. I don't know, probably dictated by Dr. Bahar Posey in the emergency room. I'm sorry, what was the question?
Under the physical exam, does it note that under heart rate, she is tachycardic?
It does, and it states that her pulse rate was 134.
That's very high
Very
in
high.
a child of this age, is it not?
Well, 250 would be very high. It's elevated at 134.
Okay, that's not normal, is it?
Probably not.
Why did you put here in your report there were no abnormalities noted on her exam if she had an elevated heart rate that it can be associated with a child in pain?
I don't know.
Okay. So if you've got, if she's tachycardic, if she has problems with her eyes from the light, if she has her knees flexed into the abdomen, if she has allodonia, meaning she doesn't want to be touched, and she has lesions, you've got 5 symptoms of RSD right there, do you not?
No.
Okay. You're saying allodynia is not a symptom of RSD?
It is.
You're saying that, what do you call it when you're light sensitive? You're saying that's not a symptom of RSD?
No, I'm saying she was wearing eye covers. Was she photosensitive? I have no idea.
Okay. She did not want to be touched.
That is correct.
That's a symptom of RSD.
It could be.
All right.
Could be a behavioral manifestation.
Okay. And she had a fast heart rate, right, which supports being in pain, does it not?
It could.
Knees are flexed up into the abdomen. That can be an indication, right?
That's a positional description. I don't know what that has. I don't know if that has anything to do with CRPS criteria. It certainly isn't Budapest criteria, to my knowledge, that positioning yourself with knees up to the chest is confirmatory objective evidence of CRPS. I'm there to evaluate whether there is evidence to support a diagnosis of medical child abuse. I'm not there to complete my evaluation unless I have to by saying, I don't know, this is all the information. It could be either, you decide. My task as the child abuse pediatrician is to evaluate all of the medical records, look for every piece of objective evidence that I can, evaluate all of the information in context, look at objective observations both in the presence and in the absence of the alleged perpetrator, and try to put all that information together to assess whether or not there's sufficient evidence to support a diagnosis of medical child abuse.
Let's on to part 3.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Doctor, this letter was faxed to your office on November 3rd, 2016, correct?
Yes, I think we established that.
Why did you not mention Eagle's Wings' history of treatment of Maya to the court on November 10th, 2016?
I don't know if I was asked about it or not.
How is it that there's not a single mention of Eagle's Wings in your December 5th, 2016 report?
I don't know.
Again, your role and your stated goal was to be thorough, objective, and comprehensive in providing your report to the court, correct?
I provided this report in my role as a medical director for the child protection team. I believe it was eventually, presented to the court. At the time that I did this deposition, the report wasn't completed, so I don't know. I mean, I'd have to read the whole thing to see what, if any, discussion there was about Eagle's Wings Counseling Center in that. If somebody asked me about it or not, I don't know.
All right. Table 6.2, the last bullet point, recommendations for confirming infectious disorder by proxy. Consider covert video surveillance. Did you, in fact, consider covert video surveillance?
There was... I believe there was a day or so that there was some videotaping of the child in her hospital room in an attempt to document the amount of movement that she was and the activities that she was undergoing in her room when people weren't present or when doctors weren't present.
Who directed the video surveillance?
I guess I don't know. They have... a setup at the hospital.
Who directed the video surveillance?
I had discussion with the hospitalists. I don't remember exactly which one it was at that point in time about the possible benefit of that activity.
What did you find with the video surveillance?
There were numerous instances during the video which were comparable to numerous observations of the physical therapists, the nurses, the child life staff, the music therapy staff, etc., of the child moving around in bed, putting her feet in normal neutral position, using her upper body, her lower body in various movements that provided concrete evidence in support of all of the observations that were made by numerous hospital staff.
How does any of this indicate child abuse?
How does any of what?
The concrete evidence of her video of Maya Kowalski in her hospital room.
That was related to, I mean, she's 10. So as the children get older, there can be a component of the child having been sort of participating in the medical child abuse. One of the ways that this occurred in this case was that the child had very inconsistent patterns of movement and reports of pain in response to certain movements, and numerous other observations that were made by the hospital personnel. So this was an instance in which there was specific objective documentation that could be presented, if necessary, regarding what was being described and reported by numerous treating providers at the hospital.
How much involvement did you have in Maya's care from the time of her admission throughout her sheltering at Johns Hopkins?
So as of October 13th, you mean? I talked to several physicians. I think we've talked about that already. I reviewed information as I was preparing my report.
And beyond October 13th, up until the time of your report, how much involvement did you have in her care?
I was not a treating physician.
That's not my question. How much involvement did you have in her care?
I had conversations with some doctors.
Did you direct any actions?
I had discussion with several doctors at various points in time regarding things that could be considered to improve Maya's safety and her and the effort to have her have a more effective separation from her mother. There were a lot of times when she was Skyping with her mother, even though she was sheltered in the hospital, and so there were some discussions related to ways to minimize effects on her safety related to that.
Beyond discussions, did you direct any actions?
I don't believe so specifically, no.
Did the hospital look to you for direction?
I had discussions with several treating physicians at points along the way while she was admitted.
All right, let's look at what we'll mark as Exhibit 7. Dr. Smith, this is 2 sets of text messages between yourself and Dr. Major and Dr. Deese. So let's turn to the 3rd page of the exhibit. And these were produced from your phone, correct, Dr. Smith?
Yes.
To orient the jury, as we look down through these text messages, we see, for example, in the 2nd text message, reply from SS. Who would SS be?
Me.
And reply from PD. Who would PD be?
Paula Deese.
Okay. So you have her number in your phone?
Yes.
She's a saved contact?
I believe so.
Okay. Let's look at the 2nd text from the bottom. This is a text from you to Paula Deese where you state, "We may need to try to monitor what she's doing online. I wouldn't put anything past her mother."
I'm sorry, where are we?
Page 1 of your text messages.
Oh, okay.
So when you called Cindy, what did you learn?
I don't know.
No independent recollection?
I went there and I talked to some people. I don't know if Cindy was one of them. And I vaguely recall looking at some of the stuff. I know we had some discussion about what they had seen and what they had captured on the video in terms of whether I really looked at any long review of that. I don't believe I did, but I think that I did have a discussion with, excuse me, the people in that office about what they had observed, which, as I said earlier, was essentially documentation of many of the things that were being observed by the physical therapy, occupational therapy staff, child life, music therapy, in terms of inconsistencies about what Maya said she could do, and the pain that actions would cause, and what she would do when she was just acting on her own without somebody asking her to do something.
Doctor, do you also intermingle the professional life and personal life in your personal email address?
I don't use email related to patient care. I do receive email from, for example, the medical staff office on my personal email.
Okay. The medical staff office of whom?
Johns Hopkins Children's Hospital.
All right, Doctor, we've spent some time discussing your use of different devices and technology. I'd like to direct your attention now back to the text messages as previously marked as an exhibit. The response to the fifth request for production from August 30th, 2019. And I'm on what's at the bottom, page 2 of these text messages. There's a message from October 21st, 2016 at 12:50 from you, doctor, to Dr. Deese. It says, "Hey there, just a few things about Maya. Do you have a minute for me to call?" Do you recall what you wanted to discuss regarding Maya on October 21st, 2016?
No.
Do you recall how long the call was?
No.
You were in close contact with the hospitalist, Paula Deese?
I had a number of communications with her during the time that the child was in the hospital.
All right, it looks like an hour and 9 minutes later at 13:59, perhaps after discussion, you write, "Also, probably already in progress, but maybe get her off as many meds as possible." You're suggesting action to the hospitalist on the case at this point?
We were discussing elements of the case and the care.
Do you agree with the characterization that you're suggesting action on the part of the hospitalist?
As it says, I texted to her, probably already in progress, but maybe get her off as many meds as possible.
Would you agree that's a suggestion to the hospitalist?
That was part of our text discussion regarding recommendations. So I guess it was a suggestion. I don't know in what context.
And it's a suggestion related to Maya's medications while she's sheltered at Johns Hopkins, correct?
I believe I just read exactly what it says.
Do you agree with that characterization? It's a suggestion related to Maya's medications while she's at Johns Hopkins.
It was apparently a proposal related to her medications.
Is the decision whether or not to take Maya off of medications an evaluation?
As a child abuse pediatrician that provides assistance to many doctors at Johns Hopkins Children's Hospital, I sometimes discuss with them testing or treatments or things like that that may be helpful for either the child's well-being or for some element of my evaluation or things like that. In my view, the things that you're talking about here were discussions that I had with a couple treating physicians on a few occasions related to things that would improve my safety and assist in minimizing the effects of the medical child abuse.
Thank you,
Were
CLO.
they treatment decisions?
I'll try to remember that.
Medication. Is that a treatment decision?
That was just a discussion that I had with the treating physician in terms of whether or not she, how she responded to my discussion or recommendations or suggestions to her. That's up to the treating physician.
Is removal of someone from medication a treating decision?
If I had gone in and written the orders myself and directed exactly when a dose was decreased and what medication was discontinued when and things like that, those would be treating decisions. Having a discussion with this physician about a child that we were both providing medical care for and medical evaluation for is not, in my view, a situation in which I was providing treatment for the child.
So a treating decision is only made by the person that undersigns a particular progress note and not by the team that consults in making that treating decision?
All of these things, we've talked about were something I said maybe, something I said consider, are you doing this, things like that. So I'm not directing them to do specific treatment. For example, with the removal of medications, that had already been ongoing and mostly completed when I asked the question. So clearly that wasn't based on something I told them to do. That was based on all of the treating physicians at the hospital, the pain management team, the hospitalists, and whoever. I said something about maybe get her off as many meds as possible. Yep, last med coming off today. So it's not like 7 minutes later they had removed all of her medications based on my recommendation.
My question is very simple. Is removing medications from someone a treating decision? Yes or no?
I don't know.
You don't know if removing someone from medications is a treating decision?
It depends on all the circumstances and stuff in terms of whether that would be considered treating and, that kind of thing. I mean, certainly that would be one thing that a treating physician might do.
Wow. Hedging
Doctor,
just a
raise your
bit.
right hand, please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Has your position insofar or role with Johns Hopkins All Children's Hospital changed in any way?
I continue to be a member of the active medical staff. That's my only relationship with Johns Hopkins All Children's Hospital. I don't really know anything about how people at the hospital have some sort of employment or relationship or title or anything.
Who would you say was the person that you had the most contact with during the period of Maya's placement at Johns Hopkins All Children's Hospital? Which doctor? Would it be Michelle Smith? I mean, who would it be? Tepa Sanchez? Would it be Malik Farad? Who would it be?
My recollection, I spoke to Dr. Tepa Sanchez about the child once. I spoke to Dr. Vos about the child either once or twice. I never spoke to Dr. Malik.
After Beata's suicide, did you receive a call, text, any other communication from Dr. Major?
Is she looking on her phone right now?
Dr. Major and I exchanged a few text messages on January 9th and January 10th of 2017, all of which I believe have been previously produced for you.
I'm wondering, when was the last time you worked on a committee other than the credentialing committee?
Most of the committees that I was on, I left in 2004 when I left my employment with the hospital. I was a community pediatrician representative to the Medical Staff Executive Committee from July 2011 to January of 2016. Since January of 2016, the only committee at All Children's that I've served on is the Standards and Credentials Committee.
And for your work training residents and interns and otherwise consulting, how are you compensated?
I'm not. I'm volunteer.
How many hours a week would you say that you devote to training Johns Hopkins residents, interns, and doctors?
Personally, close to zero. They primarily work with the nurse practitioners with our team.
Under you?
I supervise them, yes.
Without naming any names, can you give us some examples of the type of consulting you've been doing? I mean, what, is it a broken leg? Is it fever? Is it a child with hysterics? What kind of situations can you think of that you provide consultation?
Llevamos. Thank you.
With the residents and the
Patricia,
medical
thank you.
students?
Right, or the doctors.
Well, residents are doctors.
Granted, but
it's very random. So the children that come here are coming here for medical evaluation for alleged child abuse or neglect. If I'm here and I'm available and the nurse practitioner has seen an interesting child with them or might have a question about a child that they've seen and wants me to help review with them to guide them, then if the resident happens to be present, they might hear the discussion that we have. I would say over the 10 or 15 years on maybe a few occasions, I've recognized a resident that was here who I might have seen or I knew was involved with a child that I saw at the hospital, and we might discuss that child in more detail. But that's happened maybe less than a half dozen times over the last 10 years.
Now, let me ask you about the credentialing committee. Is that who determines who can strike it? What kind of credentials are you talking about there?
So anyone who is providing medical care at the hospital or in the outpatient setting in some circumstances has to be approved based on their credentials. Standards and credentials committees are standard at medical facilities, and that committee reviews resumes and recommendations and lists of procedures performed. We used to interview the people who were applying for privileges, but that's changed over the years, and now we only occasionally do direct interviewing. And then the committee makes a recommendation to the medical executive committee about whether a person who is applying for privileges with the hospital should be approved. Then the medical executive committee in turn presents the information to the board of trustees for approval.
Thank you. So this is what would be known as privileges? Is that the same thing?
These are people who are applying for practicing privileges at the hospital.
So when a doctor says, I've got privileges at that hospital, this is what you're approving?
We're reviewing their information and making a recommendation to the next step, as I went through.
Does that mean yes, colloquially, when a doctor says I have privileges somewhere, if they want to have privileges at Johns Hopkins, your committee is one of the hoops they jump through?
They have been presumably vetted by our committee, and a recommendation to approve staff privileges has been made.
All right, let's start off with employment. At the time that you rendered services for
this is cross now.
medical protection team, who were you employed by back in 2016 and 2017?
At that time, as the medical director of the child protection team, I was employed by, Suncoast Center Incorporated and the state of Florida Department of Health.
Were you employed by Johns Hopkins All Children's Hospital during that interval of time?
No.
Specifically, plaintiffs have indicated that you completed your residency at Johns Hopkins All Children's Hospital. Is that true?
At the time that I was in the residency program from July of 1984 until the end of December of 1985, it was just called All Children's Hospital. It was not affiliated with Johns Hopkins.
Okay. And in briefing, I believe there's also a claim that you took a faculty position at Johns Hopkins All Children's Hospital. Is that true?
No, again, I worked for All Children's Hospital, not affiliated with Johns Hopkins in any way, from 1990 until, from July of 1990 until, I believe, November of 2002.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Any claim to the contrary would be untrue?
Correct.
How does it work? It seems like from what you've testified previously that you were medical director of the child protective team, but that you were both employed by Suncoast and Department of Health. Can you kind of explain that dual employment arrangement?
Yeah, so as the medical director of a child protection team, I received direct compensation from the Department of Health for some components of my responsibilities. Typically, that has been about 17 and a half hours per week for the last, 10 or 15 years. The Suncoast Center Incorporated holds the contract for the Pinellas County Child Protection Team. I believe they have done so since 2008. And so, in addition to the direct compensation that I get from the Department of Health, I also am in the role of the medical director for the child protection team under Suncoast Center.
Over the years, my understanding is you've served on some committees with both All Children's Hospital and later Johns Hopkins All Children's Hospital. Is that correct?
Yes.
Okay. And pertaining to the times that Johns Hopkins All Children's Hospital, strike that.
Scratch all that.
Were you ever compensated by Johns Hopkins All Children's Hospital for any committee service?
No. Back when I worked for the hospital, obviously I was participating in committees during time frame that I was, an employee. But since November of 2002, I have not received any compensation of any sort for being on any committees.
Okay. So it's fair to say since around approximately the turn of the millennia, you have not been employed by All Children's Hospital?
Not since November 2002.
This Fifth Avenue Pediatrics listed on your CV from March 2003 to the present. What is Fifth Avenue Pediatrics?
That's the current name for the private practice that I'm a partner in.
Is that private practice affiliated in any way with Johns Hopkins All Children's Hospital?
No.
My understanding is you were first contacted by a Johns Hopkins All Children's Hospital physician in this case on or about October 8 of 2016. Do you recall that conversation?
Generally, yes.
At the time that you were reached out to by Dr. Tepa Sanchez, were you receiving that call as an independent medical staff position?
If I understand the terminology correctly, yes.
Okay. Well, why don't you explain the difference between when you get involved in a case as a CPT versus if a doctor who needs a consult just contacts you?
Well, technically the child protection team can be involved in a case if there is a report to the abuse hotline and either an investigator with Child Protective Investigations or law enforcement requests for us to provide a medical evaluation. There are some cases over the many years I've been involved with All Children's and now Johns Hopkins All Children's where that may or may not have occurred as yet, but a physician, knowing my expertise in child abuse pediatrics and my capacity as an active member of the medical staff, will contact me directly to ask questions about a case that they are seeing and seeking some guidance about whether or not there may or may not be abuse or neglect in the case.
Is there anything wrong or unethical about a physician who has suspicions reaching out to a child abuse pediatric such as yourself for some insight?
I can't imagine why there would be. For example, if somebody, if a doctor thinks that a child might have a heart problem, but they don't know exactly how to proceed with further pursuing that, they wouldn't be unethical to consult a cardiologist that's on the active medical staff for guidance. I think consulting an active medical staff member with expertise in child abuse pediatrics, in my view, would be the same thing.
Is it fair to say that when you were rendering services to in this case, that you were exercising your independent professional judgment?
Yes.
I guess my first question for you is, did you have a customary practice back in October 2016 and into 2017 as to how you would introduce yourself to a family where you're doing a CPT investigation?
Yes, I would state that I was Dr. Sally Smith and I'm a pediatrician with the child protection team.
Do you recall doing that with Beata Kowalski?
Yes, I've testified in depositions before that Mrs. Kowalski knew exactly who I was. The timing of the meeting with her, et cetera, was arranged a little bit ahead of time so that I knew she would be there and she knew I would be there. And I believe there were people from Protective Investigations that were present during the interview.
Do you actually recall introducing yourself as the medical director of the child protection team to Beata Kowalski?
Yes, I do.
Okay. And do you recall the same with respect to Jack Kowalski?
Yes.
You introduced yourself at that time as the medical director of the child protection team?
I may have introduced myself as a pediatrician with the child protection team. I don't know for sure that I said specifically medical director.
Sure. But you would have said something about your role with the child protection team?
Absolutely.
Earlier this year. Did you ever represent to Maya Kowalski that you worked for All Children's Hospital?
No.
Did you ever represent to Beata Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever indicate to Jack Kowalski that you worked for Johns Hopkins All Children's Hospital?
No.
Did you ever prescribe medication for Maya Kowalski?
No.
Did you ever enter a progress note in Maya Kowalski's medical chart?
No.
Okay, to the best of your recollection, were you wearing a white lab coat with Johns Hopkins insignia on it when you met Maya Kowalski?
I don't have and have never had a lab coat with the Johns Hopkins insignia on it. I definitely wasn't wearing any such thing when I saw Maya Kowalski on either of the two occasions that I saw her.
Did you direct anybody with respect to Maya Kowalski's care and treatment at Johns Hopkins All Children's Hospital?
In the course of her hospital stay, there were times that I spoke with, I believe, Dr. Deese and Dr. Major with regard to the issue of medical child abuse and some things that could be considered in terms of demonstrations of movements that she was making that weren't consistent with the reported diagnosis of RDS, or what they're calling now complex regional pain syndrome. I had discussions with people about her course in the hospital, but I never was directing any treatment for her.
When you're working as, the medical director of the child protection team for Pinellas County, is it common for you to discuss aspects of a patient with the patient's treating providers?
Yes.
And to your knowledge, did Johns Hopkins All Children's Hospital ever hold you out as Johns Hopkins employee or agent while you were rendering services as the medical director of the child protection team in Pinellas County?
No.
Okay. And at some point, I understand you talked to a Dr. Anthony Kirkpatrick. Do you recall doing that?
Yes.
What do you recall about the conversations you had with Dr. Kirkpatrick? Generally speaking.
So what I recall was that I think he called and left a message, and I called him back. And the one thing I definitely remember was that he told me that I should not evaluate the child for Munchausen syndrome by proxy because that was not a problem in the case.
Okay. And did you consider his advice?
Well, I certainly heard him, but if I had heeded his recommendation, I would not have been doing my job. And,
what do you mean by that?
Well, my job in this case was to respond to the request from the investigators and law enforcement as to whether there was medical evidence of child abuse or neglect in the case. And the only way to do that when the concern is Munchausen syndrome by proxy or medical child abuse is to gather extensive medical records as much as one can, review all of those medical records, put that in the context of information that may be directly obtained, such as the information I got directly from Beata. Ordinarily, one would consider one's physical exam, but in this case, I was unable to conduct a physical exam on the child, and then put all that information together to try to determine whether there's medical evidence of child abuse. So if on October 11th or 12th, or 13th, when I spoke to Dr. Kirkpatrick, I had just said, oh, Dr. Kirkpatrick says there's no Munchausen syndrome by proxy here, so there must not be, I would not have been doing my job.
Do you know who Dr. James Lewis is?
Yes.
Who is he?
He's a neuropsychologist. At the time Maya was admitted to the hospital, he was a consulting neuropsychologist for the child protection team, and he provided a neuropsychological evaluation of her as part of the evaluation under the child protection team.
And he's not a medical doctor, is he?
No.
I believe he's a PhD.
Correct.
Is it common for people like Dr. Lewis to perform a psychological evaluation of a child who's the subject or whose parents are the subject of an ongoing investigation?
He was doing so probably about 20 or 25 times per year at that time.
Well,
the judge is watching
he was
this
employed
intently
by
like
back
this.
when he consulted with Maya Kowalski?
He was contracted with the child protection team, and so when he would provide a neuropsychological evaluation for a child who had been, referred to the team for assessment, I believe he would just submit a fee-for-service type invoice or something to Suncoast Center.
To your knowledge, was he employed by Johns Hopkins All Children's Hospital?
To my knowledge, he was not.
Other than the grand rounds that you've discussed, do you have any evidence that you received any compensation from Johns Hopkins Children's Hospital?
I have not. Case.
Well, that you were well, you never even told her that you were investigating her for allegations that she committed child abuse, did you?
Well, based on Mr. Hughes's report of her email, I think we could, have a discussion of what she understood about what I was doing. But
no, this is about
I
you.
introduced myself as a pediatrician with the child protection team. I did not go into major detail about what that meant.
And you did not do that with Jack Kowalski, did you? In that first interview with him, let me finish my question. In that first interview with him, you did not tell him that you were investigating him for possible allegations under allegations of child abuse of Maya, did you?
I introduced myself as with the child protection team. I did not go into detail about what that meant.
And you did not tell Maya Kowalski, in your version, that you were investigating her parents for child abuse, did you?
I was taking a medical history from the people in terms of instructing them about that I was an investigator or something. I did not do that.
Just out of curiosity, what were you wearing when you interviewed the Kowalskis?
Business casual street clothes and ID badge.
Well, okay. And what does the ID badge say on it? Does it have your name?
Yes.
And it has Johns Hopkins on it.
It had a logo for the hospital, as an ID badge would.
And what field of expertise did you hold at the time that Dr. Tefa Sanchez contacted you on October 8th?
Child abuse pediatrics.
Okay. And you had active staff privileges on October 8th?
I did.
You had privileges at Johns Hopkins?
Yes.
All right. So she says she was not wearing a white lab coat. Here comes the last one. Was that the last one, or we have one more? See if the judge can find the light switch. I think he can here.
I'm so proud. I'm so proud of myself.
He's chuffed.
Can I see the attorneys for just a moment, please?
He's grinning from ear to ear. This is going to be a discussion about lunch break, because the judge, as the attorneys come up, he's going to look over at the clock as he's talking. There he is. He's looking at the clock. So here we go. It's like, how much more? They look at the clock again. That's where the clock is, over the jury's heads. They're discussing when they should break, how long of lunch we should take, what business we have to go into. Add about 100 objections to that. They're all talking about, hey, I heard about this new restaurant the other day from a witness on the stand that just had a grand opening, and maybe we could go there for lunch. You want to type a question or ask? I just want to ask the lawyers on that. Mrs. R.A. has a question for the lawyers on here. Hang on one second.
I am just a little confused when it comes to the depositions that are being shown in court, because when they're being deposed, there's nobody there protecting them like the judge protects them, that says, no, you can't allow those types of questions. No, that's not relevant. I mean, I guess maybe the other attorneys there and could be making the objections, but there's no neutral party that's taking care of that. How is that allowed into court when the actual court is so protective of each of the witnesses?
Well, the other party does make the objection, and then the judge goes through the deposition, and if it's sustained, I think they cut it out. So that's why we have so many cuts and jumps in this. The depos are heavily edited. They do have lawyers there. You're not just sitting there with the opposing counsel and getting grilled. But all this is done. But it's a great question, says TJ Bates. Great question. The judge is not there during the deposition. That's done after the fact. Here comes a follow-up question from Mrs. R.A.
Okay, awesome answer. So here's my next question. Oh, I don't know how to use microphones. Okay, the follow-up question on that is then why do they use depositions and not just bring people in? Because I was listening last night to Rob, and he was talking about how there can be deposition scarring, and I'm not exactly sure what that means, but I think it sounds bad. So why use the deposition? Why not bring them in?
I think in this case, obviously depositions are used at times when a witness is not available. I'm not sure if she was not available or not. Hang on, let's let the judge talk to us for a minute. Counting up, adding to the shot clock. Time. I think sometimes you really want their attitude in the depot to be presented. I think they would rather have what she presented in the depot.
Members of the jury, I mean, you probably figured out what we were doing. Just trying to figure out timing and lunch. And it probably is best that we don't start. So what that means is, why don't we take lunch now? I'm going to ask that you be back and ready to go, Deputy Coley, at 1 p.m. So about an hour and 35 minutes. So do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
So they have an hour and a half, which means we've got a little bit of work to do here during lunch. So hold tight here for this. Let me switch to another feed. Source 2, 3. We'll figure out where we're at. Hold tight.
Okay, thank you. The jury's out of our presence. Everyone can be seated. Why don't we come back at 12:40, which is an hour and 15 minutes from now. That'll give us 20 minutes to discuss whatever we need to discuss.
Judge, can I raise one quick issue, or do you have to go?
Hopefully it's quick.
Well, Judge, in reviewing the video for Dr. Neuberger, I didn't actually watch the video. I just read what they said was on the video words. I'm not anticipating any exhibits coming up, and I just need to find out, are they going to be flashing pleadings or things during the video? Because I didn't watch it. I took their word that this was what was on the video.
And I saw that in Dr. Smith's, a couple of them, we did cover up whatever was being shown to her at the time. So.
One was a pleading. But in any event, that's my question. Is it just the doctor, or are they going to be flashing up documents? Because I didn't watch the video. I didn't think that was necessary.
No flashing allowed, please.
I haven't had time to watch it myself, but I'd suggest, is that solution acceptable, that we cover things that come up on the screen momentarily? That box? Quicker.
The court's like, it shouldn't be there.
If there's going to be something that is not in evidence, it absolutely needs to be covered, or somehow not shown to the jury.
I understand.
She is very exhibity.
Part of it and read the transcript.
I've just said what has to happen.
Judge ruled.
I trust that directive is going to be taken care of.
Judge, as to the Sally Smith video, at approximately 111 minutes, 10 seconds, there was a response by Sally Smith where she said, and we had objected to this, she was responding to a law enforcement request that she conduct an investigation. So that is flat out true, and there's absolutely no evidence in this record that Dr. Smith was ever contacted and assigned by the police department or the sheriff's department or anyone else. And so we would like an instruction that although the question and answer were allowed, there's no evidence in this record that Sally Smith was acting on behalf of the Sarasota County Sheriff's Department or anyone else.
Well, hold on a second. Wasn't the testimony, if she get a referral from the hotline or law enforcement, I think was what the...
It was an alternative.
I don't recall her saying in this particular case that law enforcement requested her.
I will double check the transcript. Maybe I heard incorrectly.
Let's double check, because I think there was an or, and I did not, sitting here, I didn't get the perception that any law enforcement requested her.
We just want to make sure, of course, that the jury doesn't get the idea that she was under there for any particular tasking by the Sheriff's Department, the State Attorney's Office, or anything else. The only other thing at this point we wanted to just start out, we can talk about it later, is that...
If we're going to talk about it later, let's not talk about it now.
Okay.
What time do we need to be back there?
12:40.
Let's be back at 12:40.
They're coming back at 12:40, which means we're going to be back at
Thank you very
12:30.
much.
That gives us a 10-minute break.
Now, when I say let's talk about it later, is this some sort of motion that's already been filed that I need to be ready to go on, or is this the issue that was from this morning?
It's an issue that just came up this morning.
That
we
issue,
filed a memorandum on it, but we have not filed a memorandum on it. It came up through the course of Sally Smith's deposition, but I can present the motion. It's an ora tennis motion to conform the pleadings to the proof in this case.
Well, why don't we'll deal with that one later.
Judge just lost his lunch appetite.
Thank you.
We'll deal with it later.
All rise. Court's at recess.
So get me out of here. Get me to that restaurant, that brand new Greek restaurant in town that we heard about yesterday. Everyone's headed there. The jury's headed there. All the attorneys probably get a table. I still find that funny. That was it Dr. Corcoran? Yeah, it's Dr. Corcoran. I think it was Joseph Corcoran that was talking about his wife's restaurant chain that just had the grand opening and the locations of where they're at. I swear, if he hadn't been cut off, he would give us the whole lunch special. He would have read the menu to us and given us his personal favorite. Maybe even had an exhibit of some of the dishes from that restaurant. It was so funny going into that. It's like, hey, you've got a captive audience. You know, least you can do is tell them. You know, Valerie says I'm still craving a gyro. A hero. It says gyro there, so. I called them gyros even when I got them, and I've eaten them, but I guess that's because I'm not Greek. It's all Greek to me. All right, free marketing and advertising. Remember, usually we see that. Sometimes you'll get like a witness that comes in, and he'll come in wearing like his company shirt because he owns a company, and he's like positioning himself so that the logo on the shirt's up high. He's like, making sure it's visible on the cameras. It's really funny. I always get a kick out of that when that happens. He's proud of his wife, and Anderson did ask. Yes, he did. So he opened the door for him to do that. Big thanks to Patricia Sisko. Welcome to the gallery. Good to have you there with that new color of courthouse by your name. Appreciate that. We have, it's been an interesting morning. We just had Jessica Blackrick. I think Blackridge. I cannot remember if it's a k or a sh at the end of her name. I have to be careful how I say those. Anyway, she was the guardian ad litem, the court-appointed lawyer for Maya. Shapiro crossed her. The spiciest thing that happened was there during the cross when Shapiro asked a question about the dependency court hearing where the family did not object to the shelter order. And the witness had said yes. And the question that Shapiro had asked, he had presented it in such a way that was like, didn't you have notes? Haven't you? Isn't this a record from this type thing? Didn't you make a note about this during the shelter hearing that the family didn't object? As the witness is saying yes, Mr. Anderson is saying objection and, screaming, jumping out of his seat. And judge issues an order saying, sustained, disregard that, the question, the whole thing. But then we went back and revisited it because he should not have gone there at all. And it was wrong on 6 different levels. And surprisingly, even though we talked about a mistrial, a motion for mistrial was not made then, but the defense has until after lunch to decide on this, if they want to ask for a mistrial because of that. So during lunch, they're going to call the Kalowskis and say, hey, guess what happened today in court? Mr. Shapiro stepped in it. Smells real bad. What do you want to do? And there's a possibility that the Kalowskis would say, yeah, let's go for mistrial. I don't think it's a big one because I think the Kalowskis and defense think they're winning this case. They think the hospital's backed into a corner and is swinging madly trying to fend off, a row of angry jurors. But I think they think they're winning. So I don't think they're going to ask for a mistrial. I would be surprised if they did after lunch. I think even if they did, I don't think the judge would grant it. So then you've got the situation where if the defense thinks the judge won't grant the mistrial, they might ask for it knowing that he will deny it. So there might be some strategy at play there as well. Ivy Brilliant says, great news, I got promoted today, taking over the sales department in addition to my marketing job at no pay raise. Yay. It's one of those lateral promotions, Ivy. Champagne is on me, everyone. Haha. I love those lateral promotions. Congratulations. Now I do twice the work for the same amount of pay. Is the shelter order them keeping Maya at the hospital? Yes. Yes, it is.
Okay, so to clarify,
So, Ms. Zari has a question. She says, so to clarify, he was saying, who's he? Him stepping up, Shapiro? Yeah. We're saying that the whole thing he said was, do you want the microphone?
Yes, that
Okay.
confuses my brain when he does that. So I'm just trying to clarify here. When Shapiro gave that confusing question, the whole point of him stepping in it was basically saying, hey, parents, you didn't object when we said we were going to keep your child. Is that what happened? And that wasn't supposed to be brought in? I just need clarification. What did he do wrong and what happened?
Okay, everything in the dependency hearing is shielded in behind an iron curtain and under a huge impenetrable umbrella. Yes, Ms. Zari says of evil. Yes, but this is a separate hearing. This is a court order under Florida law. The participants in there, including the hospital, in relation to what they did with that hearing, they are protected legally. The judge looks at the law and says, no, you can't go there. We can't relitigate that because that's a separate trial. That's a separate court process. We're not going to fight that again here in this trial. So you can't bring that up. And the plaintiff has been admonished several times when they got too close to that line. And here we have the defense who now steps right into it and, talks about what happened during that proceeding. And so that was the no-no. He should not go there.
This is me just making sure I understand. So CSRA, the other one, the bad one, the horrible people who steal families. What are they called? CPS. CPS is having this trial, and they're trying to prove that they are superior to families, and they have a closed court because, of course, they can't do this in the light of day. It might actually shrivel and die like the green witches they are. But the point is that they have this trial, and then it gets closed, it's done, that's completely done, it's not a part of this trial. And so now Shapiro trying to bring that in is trying to cause a mistrial, trying to throw this over because it doesn't belong in this trial, because this trial is simply what the hospital did wrong, not what CPS did wrong. Is that correct?
I was getting corrected on pronunciation. I wasn't listening. Chat, can you answer my wife's question so I don't get in trouble over lunchtime? That would be great. Kalowski, not Kalowski. I'm putting the L first. That's what I was being corrected on. I didn't know what you guys were mentioning when I was putting the L first, but it's in the family name. Kalowski. Kalowski, I think. Kowalski. Oh, I can't do it. Dang it.
Scratch all that. Oh, that was terrible. I apologize.
Okay. Anyway, she is exactly correct, says Red Pen. So you're right. Yes. Big nod. That's what I was thinking as well. Hang on. I'm done. Are you making me lunch?
More thoughts. I have more thoughts. So then, do you guys think that he was honestly trying to throw this? Like, why would he do this? Why would he step in it when up to this point, he's really been in a powerful position? Anderson's getting in trouble all of the time. And now suddenly Shapiro's like, oh, sorry, I ruined the whole thing. Do you think he was trying to throw it?
I don't think he's trying to throw it. I think what we saw here is what you typically see in a boxing match, where somebody's behind, they're losing, they're backed into a corner, and they go for the uppercut, but somehow they hit below the belt, right? And just like, oh, sorry, ref, my bad. I was going for an uppercut, but somehow I ended up being a low blow, and they get a warning, right? And that's what it was. Yes, I think it was intentional, but at the same time, it's the other guy got hit below the belt, and it hurts. And so that's what we're going to do is hear from the plaintiff, from the Kowalskis, from the K family, Mr. Anderson's side. Can we just settle on an easy name somewhere, please? I'm struggling here. Chat is just correcting, like it's all corrections for me. Anyway, we're gonna wait for them to see if they want to have some sort of remediation of this. If they're going to ask for the judge to specifically spell out and say, look, jurors, this is what you heard. This is what you should not have heard. This is completely wrong. This is not covered in this case. It's separate. It's bad. Anyway, Kowalski.
That's the whole thing. Okay.
I just want the food.
Not your maid. Okay, so here's the thing. This seems so weird to me now you've got me doing it. That Shapiro is getting in trouble for basically making Shapiro look bad, right? It's the hospital. It's CPS. They're all sort of this gang of bad, and the judge is separating those, but I'm not sure the jury is separating those very clearly. So when Shapiro's like, oh, haha, I let in the dark horse, I let everybody know that it was actually CPS that's the bad guy, the jury might just be like, you're with CPS. I don't see that that makes you better. I don't know that that was a good call on his part.
Amber, can you hear me? I brought Amber on.
I can.
I phoned a friend. Amber's on the line. So, Amber, I don't know what you need to say, but I am starving, and Mrs. R.A. has lots of questions. Can we answer her questions really quickly so I can get some lunch?
Yes, that's what I was calling for, because her first question wasn't really answered, or it was partially answered and not really addressed. But first and foremost, I need you to say this with me. Are you ready?
Okay, repeat after Amber. Go.
Go. Like,
Co.
Like
I messed up the
company,
first sound. Co.
Wall. Ski.
I know where this is going. Ski. Kowalski.
Put it together. Kowalski.
I will try to remember. I really will. I'm still. You know what the problem is? Cielo. I've got Cielo in my head. Cielo came in with the super chat, and I've been saying Cielo's name wrong, and that's the only thing I can hold on.
With the pronunciation in the super chat. I thought that was great.
Kowalski, Cielo. I've learned 2 new words today, and I'm going to try
There
to
you
keep
go.
it. Thank you very much, Amber.
So to help answer Ms. Sari's question from her initial question about the depositions, so a couple of things. I'm not a licensed attorney. I do not practice law. I'm just a true crime addict. However, I do have a lot of knowledge about law. So I'm going to kind of help out here, and we can have the other legal pros chime in if I'm missing anything. So the depositions are taken.
In my opinion, has been the most level-headed and professional attorney there so far. I'm not sure. I think he did it on purpose.
All right. Keep going. I'll address that from Aaron in just a minute.
So there are certain key players with this case who have passed away. And the only thing that they have is their deposition. So that would be reason number 1 to use deposition. Another would be if you're not in Florida, if you don't reside in Florida, they can't legally compel you to come back to Florida. It's not like you're going to have somebody come arrest you in California and bring you back to Florida for a court summons. They can't do that. So if there is a refusal of a witness to come back to the state, now if you're in the state of Florida, that's different. So that could be another reason for why deposition. The second part of her question, I'm sure there's more other reasons and stuff too, but those have been the 2 key ones that I've been mentioning. The other part of her question of deposition scarring. So this was mentioned last night on the recap, and it was a great explanation. So there's deposition scarring can be twofold. So you have those witnesses that report for deposition and deposition only, and that's the only thing that they do. They never go in for a trial for live testimony. So they are anxiety riddled, have no idea how to answer questions in a courtroom in front of a jury, and they fumble on everything, and they just can't compose themselves in a courtroom because they're so used to it being recorded, one-on-one asking questions. On the opposite of that,
I'm never going to get lunch. Okay, let me stop you right there and ask a question. Is it true that defense is going to call her in person on defense?
I believe they are, but I have not confirmed that for certain.
Okay, it sounds like she is one witness that can say 6 ways till Sunday that she was not working for the hospital, and that's like their best defense. They're like, she's not with us, she's not with us, she's not with us. That's going to be
the problem, though.
What they're going to hear.
The problem, and I really hope Whitney does the questioning if she comes in person, because I feel like Anderson would get flustered being in court, and we ain't got that kind of time for him to get flustered and take up all that time. So if she does come in, I really hope it's Whitney that does the questioning. Second thing is I really don't know if the defense wants to throw that wild card, because it's going to be a wild card. There's going to be a lot of things that come in that they don't want to come in because of the way she answers questions.
Can you imagine the attitude, that same body language in the witness box in front of the jury on cross?
Right. That's what I'm saying with the deposition scarring. She has a lot of these depositions that have been done and that we've seen in this case. A lot of their behaviors, a lot of the way they answer the questions, a lot of their body language, especially, would never be presented in court. This is not how you would present yourself in a court of law in front of a jury. That's the other side to deposition scarring.
Let me transition to this comment by Aaron. And Aaron, thank you for the super chat. Aaron says, Shapiro, in my opinion, has been the most level-headed and professional attorney there so far. I'm not sure. I think he did it on purpose. I will say that Shapiro is a trial attorney. This is his ballpark. Okay, this is where he goes. This is where he practices. This is where he plays. There are lots of different parts to being an attorney. There are many attorneys who really never step into a trial, never step into a court, never testify to statements in front of a jury. There are many different ways you can practice, but this is Shapiro's field, and he does know it very well. And I will say that he is very good at what he does. I agree with that, but I think it was intentional. That's what he said. Because I think he knew he could get away with it. He knew he could be a low blow and then say sorry and be able to move on.
Right. I'm inclined to agree with you there, but he's the trial attorney that Whitney is the case law attorney.
Yeah.
Because Whitney can quote some case law like it's nobody's business.
He can. We have some great attorneys on both sides. Honestly, this is a matchup of titans. Really, just some great people on both sides. We like to poke fun at them, and every time they make a mistake or something, I think they're fair game for that. We try not to be rude and mean about it, but at the same time,
scratch all that. All that was
there's some times when we can laugh. At the same time, we can make light of it. Amber, I need lunch or else I'm going to pass out right here on camera. And I don't want that to be the viral clip of me that goes around tomorrow. So thank you for calling in.
Too, so please go eat lunch.
I appreciate it. We'll catch you later, all right?
All right.
Let's see you. Bye.
He wasn't looking. Okay, so I have one more question, though. That, as Scott, you were saying that everybody here is a really good attorney. I'm just going to let that one lie. But I'm also going to say that Anderson seems to really show up in the depots. Do you think that he really pushes to have the depots used because he's definitely in a shinier suit when he's in that position?
I think the reason it's better in depots is because most of the questioning is pre-written. That he's not as good thinking on his feet with responses. The depositions, he knows areas he wants to go into, and he can go down a list and he can follow it better. Where in live testimony, the response might not be exactly what you're looking at or looking for, and it can be a little different. He is phenomenal in depositions. I love him there. Of course, we also have to say they're edited. So if he has moments of sheer fell on his face, just failure, then we just don't get to hear those. So, all right, it's time to go to lunch. Thank you, everybody. We're going to be back at 12:30, which means we have just under 45, about 40 minutes left. 40 minutes of lunch. It's going to be a quick one. We're going to be back on part 2. It's going to be spicy. Did I order lunch? I asked Mrs. Ori if she was going to make me something, and she said no. So I think I have to make my own sandwich today. But that's all right. I know my way around the kitchen too. So thank you, everybody, for being here. Thanks to the great mods who make this such a fun place. Thanks to all of you who show up and make this community what it is. It's incredible. It would not be the same without you. Thank you. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. 12:30 will be the time Eastern. That's about 40 minutes, 42 minutes now. Wow. I'll have time to eat. I'll be okay. We're going to be back. It's going to be a spicy afternoon. Can't wait for it. We'll see you then. Bye.
I object.
the guy.
Scratch all that. Oh, that was terrible. I apologize.